May I please your lordship? In item number 2, lordship, the respondent IIT authority has filed one affidavit in opposition in yesterday, lordship. That record may be called for, lordship.
Which record?
Lordship, affidavit in opposition, lordship.
IT has filed the affidavit.
Yes. Highly of.
Wait, please, Lordship. Lordship, item 4 of today's list.
Oh,
Yes. Well,
Yes.
Senior Advocate Didas is on leave, madam.
Arjun.
It will be taken up on 4th of November.
May I please, Lordship? Lord, I beg to mention item number 10, Lordship.
10. Yeah.
10, hearing matter, Lordship. I want to withdraw this matter, Lordship, as the appellant has already been appointed in another school.
He wants to withdraw, dismisses, withdraw. Yes.
Should also like to mention item number 19, 20 up to 24. All matters are relating to the challenging the ordinance. The senior engaged senior counsels are not available today, Lordship.
Who's not up to him?
Diganta Das came to this.
So what do you want?
Matter may be listed after the vacation, Lordship.
Puja vacation. The request will be appealing for that. Just after Puja vacation. There are many other consuls also.
There-
I'm here for 22, 23, and 24.
And what about 19? No problem. Puja vacation.
May I please, your Lordship? I beg to mention item number 9, Lordship.
Item number 9.
9, Lordship. Certain queries were made. I'm not prepared. Just I had made certain queries to that. So maybe after the vacation, Lordship. That's well.
So what do you want?
I would come back to reply to that after the vacation, Lordship. Will kindly fix it after the vacation. Lordship. Just made a specific query to that.
At the request of one council to the
Petitioner.
petitioner, based after. Yes.
Highly obliged.
Any other request?
Yes.
Daily list for orders item 1.
Made, please, Lordship. My Lord, in response to my leave applications, my Lord, they have filed affidavit, my Lord, and in that affidavit, my Lord, they have not stated anything so far. My para 6 is concerned, my Lord, and only
There are two applications. One is for condonation.
yes, condonation and a leave, my Lord.
Leave.
Now, why leave is why I have prayed for the leave, my Lord.
First of all, come to the condonation.
My Lord, condemnations, I'll just place what is that?
Are you opposing to this condonation application?
Basically, Lordship, they could have implemented themselves in the earlier round,
Impleted themselves?
and because they are part of this tender process, whole process, they knew that a proceeding is going on. Thereafter, judgment was delivered, and there is subsequently they did not acted upon. So whatever delay they have committed, because the learned single judge directed us to start this tender process afresh, and we have proceeded with it. So we have,
That earlier tender process, he was the party.
he was not a party, but he was interested party, Lordship. The writ petitioner did not impede him for that. They cannot attribute any delay or default on the part of
Has
ONGC.
submitted any bid in response to the advertisement or not?
In the original,
Or in the original?
original,
It
yes,
was under
Lord.
challenge before
Yes,
the learned single judge.
Yes, Lordship. नहीं नहीं वो ओरिजिनल टेंडर में तो लोग पार्टी थे ना they participated in the earlier tender process and they were successful also. 77. Last page. It will be Lead petition. Volume 1, volume 3. They are in the road of because we proceeded there. Alex just ordered. And people take it. And they presently walking. Awesome. Supervisor. He's very long. He's very whole thing, the process will go ahead in the central sheet.
Yes.
My lord.
So from our side, Lordship, it is like the Honorable Court in paragraph 12 of the judgment says, in view of the reasons cited above, the disqualification of the petitioner's technical bid was not proper, and as such, in view of this court, a fresh tender notice would have to be issued for the Sibsagar district. Accordingly, ONGC shall issue a fresh tender notice by incorporating in their tender notice a method to enable the tenderers to get to know the standard rate of HSD for Sibsagar district for each day. Consequently, the respondents are directed not to issue any notification of award to any of the bidders in respect of the NIT so and so insofar as it relates to Sibsagar district. This judgment was delivered, Lordship, on 26/2024 in the month of June. either we could have also come for appeal because the whole tender process was set aside, but we chose to go for a fresh tender process as per the direction of the honorable court. Now we are at the fag end of the tender notice.
Now, the question is that this court has granted the stay on 4th of October 2020. On the very same day, notification of award was issued. Knowing this, the petitioner or the petitioner has filed an application on 13/10/2023 challenging the very same action
Lord.
that they have issued the notification to in violation of the stay order. Despite that, he has named the persons, but he has not made party to it.
Yes, ma'am.
That can't be and the learned single judge at the time of final hearing also, nobody has pointed out
Absolutely, that is what is surprising to me also.
that at least this person should be
Heard.
provided an opportunity of hearing.
Absolutely, I fully agree, but it is not a case that he did not know. He knew,
Altogether different thing.
but so far as
It's a-
ONGC, we are the
even though if
respondents.
he's aware, even though if he's aware. when
He was
the-
sitting idle.
When the notification of award to issue, how he is agreed for that? But that's,
But whole tender in respect of Sibsagar,
the only thing which you have to look into it, that the notification of award was given to him on 4/10/2023. This fact was brought into the notice of the court by the petitioner, but he has not implemented him as.
absolutely, the
Therefore,
fault lies with the petitioner.
There is a clear violation of principle of natural justice.
I fully agree, Lordship, I bow down to this. But the only thing is that as ONCD, we could not implement them.
Certainly not. It was for the petitioner to implement.
It was for the petitioner.
It was for the petitioner.
Yes.
There is no fault on the part of the OMC,
Lord.
but it was for the petitioner to implement. Okay. The matter comes upon for consideration of the IA number 10413/2024. IA numbers 10413/2024. And this is 2804. No, leave one will
2804 is the lead.
So they want to file a appeal now.
the matter comes upon for consideration of the IA's number 10413/2024 and 2804/2024. The IA number 10413/2024 is filed by applicant with the prayer condone the delay of how many days?
47 days so far.
47 days in filing the connected writ appeal, whereas the IA number 2804/2024 is filed with the prayer, filed seeking leave to challenge the order dated 20th of June 2024 passed by the learned single judge in 5870/2023. Full stop. It is noticed that while writ petition number 5870/2023, the petitioner, the respondent, the non-applicant number,
Applicant number
non-applicant number.
first. 567.
Non-applicant number 5 has challenged the
5. 5.
challenge a condition of the tender notice dated, what's the date of the tender notice?
Tender notice was dated. Date was not there.
What's the date? Tender में some date was, the date must be there. The tender is the middle date.
New tender or the original tender, Lordship?
Original tender, my lord. Original tender number has been given in the writ petition, but without having a
Tender
date.
notice number, what's the number of that?
R16K. Your lordship, R16K
16K,
C, that is all are in
just a
capital.
minute, the R 16K
A-
C
C 23003.
003. Challenging the clause 2 of the said tender notice. Stop. The this court on for the on 410, the London single judge on 410/2023, having heard the learned concept of the parties, has ordered for listing the case on 6/10/2023, and has further ordered that till 6/10/2023, the respondent IOCL authorities shall not undertake any further process in terms of the price bid opening statement dated 26/9/2023. The ONGC tender notice was issued by the ONGC, Oil and Natural Gas. On 26/9/2023. Full stop. It appears that on the very same day, on 4/10/2023, the respondent ONGC has issued notification of award to 5 bidders, namely, there are 235 bidders, including the applicant.
Man,
Stop. The writ petitioner has filed an IA number 3252/2023. Before the writ court with a prayer for cancelling the notification of awards dated 4/10/2023, issued by the ONGC to the different bidders. Full stop. It is also to be noticed that in the said IA, as well as the pending writ petition, the applicant has not been included as party respondent. And the situation remains the same till the writ petition number 5870/2023 was decided by this court on 20th of June 2024. Stop. Para. Learned counsel for the applicant has submitted that the applicant is one of the bidder in whose favor the notification of award was issued. However, before cancelling whole tender process, no opportunity of hearing was granted to him, granted to the applicant. It is contended that as a matter of fact, the notification of award in favor of the applicant was issued on 4/10/2023, and he was continuing with the what was the work?
in view of
Water tanker.
water tanker, in view of the notification, that
And pursuant to that, he has already provided the 9 KL water tankers to the ONGC. And the same are in operation till date.
till date.
Till date. Full stop.
Malak, just I'll
This-
clear, I am clarifying, out of, there are but 8 tankers, out of which 5 has been given to us. still,
Maybe
Ah.
the notification of award was issued
yes,
in favor of you, including the other bidders also.
Yes.
No, in
That will
respect
take
of
care
5,
that.
it was
That
issued.
will take care of that.
In respect of 5, it was issued.
Five was issued. We have-
3 were remaining.
Till date, full stop. Anybody is on behalf of the petitioner? You are for the petitioner? Okay. What do you want to say?
Petition, my lord, we have not challenged, my lord, NOA. We have challenged, my lord, the price which.
You were supposed to challenge that anyway. Once it was issued, whatever the in violation of the interim order or in ignorance of the interim order, you are supposed to challenge that. Otherwise, his rights are going to be affected. Simply. But I'll learn it concept for the respondent number 5, the writ petitioner has submitted that since the petitioner has challenged the clause 2 of the NIT in question and has not challenged the notification of award issued in favor of the applicant. The applicant has not been made party respondent in the writ petition. Full stop. Taking into consideration the writ petition, full stop. Mr. D. Sekyal, and counsel appearing for the ONGC, has submitted that the ONGC was not supposed to implead the applicant as party respondent in the writ petition, and it was the duty of the petitioner to implead him as party respondent. As party respondent in the writ petition, when he was having the information regarding the issuance of notification of award in favor of the applicant. It's called. Having heard the net counsel for the parties. Full stop. The fact remains that the notification was of award was issued in favor of the applicant on 4/10/2023. However, the same has been 4/10/2023 pursuant to the tender notice issued by the ONGC. The petitioners, the respondent number 5, writ petitioner, has also was aware of the said fact and has also brought the said fact into the notice of the court by moving an IA. However, he has not made party to the applicant, party responding to the applicant in the writ petition. Full stop. The learned single judge has set aside the tender proceedings wide order dated 20th of June 2024 without providing any opportunity of hearing to the applicant in whose favor the notification of award has been issued. Has been issued and supposedly because the petitioner, because the respondent number 5, writ petitioner, and the other respondents has not informed about the said fact to the learned single judge. Full stop. In view of the above discussion, we are of the view that the IA number 10413/2024 seeking condonation of delay of 47 days and the IA number 2804/2024 seeking permission to file, seeking leave to file appeal against the order dated 20th of June 2024 are deserves to be allowed. Hence, the same are allowed. The applicant is directed to be impeded. The same are allowed. It's stop. In the above facts and circumstances of the case, we also deem it appropriate. Allowed to say, the connected rate appeal. The registry is directed to register the connected rate appeal. And it, all the respondents are so and so,
All are there.
all are there.
All are, including the
All
ISO.
the respondents in the connected rate appeal are represented through their counsel. A copy of the writ appeal is supplied to them.
We have already supplied.
The copy of the writ appeal has also been supplied to them. In the above noted facts and circumstances of the case, we deem it appropriate to stay the operation of the order dated 20th of June 2024 passed by the landed single judge in writ petition number 5870 of 2023. Yes.
In view of the judgment, my lord, they have quoted tender, 38 is the last date of tender. So,
Already, when we have already stayed that operation, all the proceedings for the claim to be kept in abeyance.
May I submit, Lordship?
Yeah.
In respect of 5, this is if Lordship is pleased to clarify, because he is interested only for 5 tanker services. Rest fee can proceed, Lordship. Because rest fee
Again, the
we have not
rest
allotted to
rest
anybody.
will again come,
No, rest we have not allotted to anybody.
not allotted to anybody, why? Then notification of award has already been issued.
No, notification was issued in respect of 5.
Yeah.
In respect of 6, 1 did not turn up, and 2 we have not issued at all.
Why?
Because the pendency of the repetition at that point of time. If Lordship allows to go ahead with the 3,
I'm continue. You need another person. Multiple litigations start over. भाग अपना करना होता है। मैंने मुझे ने कल बहुत बोला है लोग हमें इस तरह की सप्लाई हो वाटर बोलने का मतलब ये सर नहीं है कि रिक्वायरमेंट्स नहीं बाकी तो हाउ वो इज रनिंग इट नाउ हां वो इज रनिंग इट so कौन सा लॉस किया
Everywhere applicants. In the above noted facts and circumstances of the case, last minute, we deem it appropriate to direct the respondent to ONGC not to discontinue the notification of award issued in favor of the
Applicants.
Applicants. So that
That's
one line would let us continue with the other 3 because there is no services at present being provided, water services.
the respondent ONGC is free to proceed further with the
Or where the applicant has no interest at this stage.
yes, I will.
pursuant to the fresh notification, fresh e-tender, fresh tender notice dated 19/8/2024 in respect of the, what to say, other
Other 3
Other 3.
other 3 packages or what?
No, they are
services.
three
Tankers.
tankers, 3 tankers.
Other 3 services except the services already rendered by the applicants.
No,
Highly obliged, Lord.
This after, in the month of November.
Item number 2.
My lord, on the last petition.
Yes.
On the last petition, I was being directed to file an affidavit to
That
bring,
you have filed a-
my lord, we have filed that. Is the affidavit is on record?
No, it is not on record. We have
My
asked-
lord, it's there. It is.
Yes.
I've been directed to bring on record the last, what are the developments which have taken place. Apparently, my lord, they have accepted the order of disciplinary authority.
Where is
And
that?
that is, my lord, in page number 526, my lord.
Five?
Starts from 522.
Request for permission of the Revenue Department and waiting for some to accept the decision like this and say. I fully accept the. LCC revenue and committed complying with the requirement of writing.
All of them have,
They request permission to present to you. I think I told you that we can do.
starts from 519, my lord. Where those registration forms are there, where they have registered for the courses, and
The four students have submitted there.
my lord,
All the four students.
all the three students, my lord,
3 or 4?
three, my lord.
Three.
Page number 522 starts the typed copy, my lord.
Like we have seen that.
And their performance is also there, my lord.
Just a-
Their academic performance, my lord, is there in page number 490.
Yes,
The other development was their academic performance. After the court has allowed them to participate, that page number 490 is their academic performance.
490.
Yes, my lord, of my affidavit, my lord, 490. Each petitioner, how many classes they have attended in each courses, what is the marks they have received, and how is their academic performances they're performing. That is been recorded there, my lord.
No. This is not the question. Now, what the learned single, the fact which was troubling to the learned single judge or bordering to the learned single judge is also troubling us. Para number 33.
I understand.
How can we direct them to grant them this 100% weightage,
No.
weightage on the basis of this end semester examination
Yes,
without taking into consideration mid-semester examination? That
I have a my lord, answer to that, my lord, subject to what your lordships finally, my lord, get convinced. Lord, this weightage is the mark. This weightage is fixed at the beginning of the semester. It's not done. Although I prayed for 100% weightage, my lord, I'm not entitled for 100% weightage.
then
That is my prayer in the writ petition. But the weight, because at the time of filing of the writ petition, my lord, I was not aware that what weightage was given in particular subjects by the my lord, the instructor. That was not within my knowledge. So that's why I prayed that I may be given 100% weightage. Now, this weightage thing, your lordship will find from their affidavit. Lordship will kindly take up page number 213. Or lordship will kindly take up page 212.
Yeah.
This is the affidavit filed by the respondents, para 5, Miller.
Yeah.
That the deponent begs to state that the applicants were students of 8th semester Electronic Communication Engineering at IIT Guwahati. Their cumulative performance index till 07 semester was 7.42 with respect to Pudugu.
yes,
Yes. It is to be noted that they were expelled from the institute for the period from so and so, so and so. In the 8th semester BTech in Electronical Communication Engineering, there were 6 number of subjects which were taught by 6 number of course instructors. The petitioner's applicant were permitted by the Honorable Court to write on the end semester examination the details of the weightage given to various components of assessment for various courses in which the petitioner's appellant have written the above examination are presented in the table below. So these were fixed at the beginning of the semester. These weightage are fixed.
beginning of the,
Yes, these are basically, this is the total marks. This 10%, 10%, 30%, 50% are the total marks, out of which what they score, that is the outcome. Page 214, my lord will kindly take up.
but difficult
214, my lord will kindly.
in that case, any student, as per our own will, can even skip any of the, either he'll skip one quiz, either he'll skip one mid-semester examination and he'll say, okay, I'll appear in the rest of the examinations and if I'll go through, then declare me successful.
No,
That
that
is
is,
not the idea of this.
no,
course itself.
never. That cannot be an idea, but in view of the situations here,
The situations here.
my lord, lordship will appreciate one thing, my lord. Here, my lord, they were suspended in the month of
January.
January 31/1,
They were
2024.
suspended from January to June 2024.
Yes, that suspension, my lord, they continued with that suspension in the guise that they will conduct an inquiry. And they will come up
Ultimately,
with.
They have not conducted and immediately they have conducted.
So it was not that, it was not the case that we voluntarily did not participate in the mid-sem exam.
Mr. Das, in fact, Learned Single Judge has also taken note of it. That you have not, you have gone to your native places and you have returned late when the examination starts and something else.
Lordship,
You have not made any attempt. Okay, sir,
I can-
please allow us to
if-
appear in the.
if I take your lordships with the sequence of facts according to my list of dates, my lord, your lordship will appreciate that it was from the very beginning, it was the design that they will not allow us to enter the IIT premises. That I can satisfy your lordship, my lord. It was a design. My lord, 30 days, they took 30 days time to,
Ultimately, whatever the situation may be, sir.
yes,
We can't adopt this, what you are suggesting, sir.
yes.
We will adopt this, then it will compromise with the whole course and everything. Because the course was designed, the syllabus was designed in that manner to train you or train the students in a particular manner. So we can't have, okay, leave this one part and go with the other parts.
In fact, my lord, before the learned,
That would result in frustrating the whole idea of this.
I understand, my lord. In fact, before the learned single judge, the results of end semester, the marks of the end semester examination was declared pursuant to order passed by the honorable single judge. And thereafter, my lord, there was an order by the honorable single judge to make the assessment on the basis of 6 assignments that I submitted, 2 quizzes that I participate, and my end semester exam. So my contention before the learned single judge was that, my lord, even if you skip the mid-semester marks, since, my lord, whatever manner, my lord, whether I did not request you,
That
but the
idea-
fact remains,
That idea is very difficult.
My lord,
And it may set a bad precedent.
no, in
Any
the,
person tomorrow will come and say, "Okay, though I'll appear in the end semester examination, I'll be able to get the requisite marks and therefore.
no, in the, I understand, my lord, but in the peculiar circumstances of the case, my lord,
That is, that can be done under Article 142, not in 226.
no, that's also true, but it's a fact that,
That's not a domain.
no, that's true, my lord, but it's a fact that I have challenged the penalty order, and the penalty order is, my lord,
That's right, that's right. But
It's-
now
it's-
this situation, looking to this,
because there were, they were asked to.
and what would be the effect of this, your undertaking?
My lord, I have an answer to this, my lord. Your lordship was pleased to allow me to take admission without prejudice, my lord. Now, they have taken this undertaking from us by threatening that we will not allow you to appear in the placement, because in the placement, my lord, we need to give our biodata and all these things and other documents also. My lord, they called us that you have to give this undertaking then only we'll permit you to.
Force.
Yes,
Absolutely false, my lord. Absolutely false. Because they themselves approached, my lord,
In
and
fact, this is all probability that you ask them, give us undertaking.
my lord,
But ultimately, this court has already ordered for that without
Prejudice, yes.
my lord, if I may just clarify one single point, my lord. In response to that court's order, their admission was given. Subsequently, this event had happened very recently, my lord. When they approached the authorities and they said, we are accepting the order, allow us to be participate in the placement.
If
That means you stop.
No.
Would have come here and withdrawn that appeal itself.
My lord, that instruction they would have passed on, my lord.
That was
I am
open
not
for them.
privy to that.
That was open for them. We are accepting this and therefore
Yes.
that is under compulsion.
My lord, I'll respectfully submit, my lord, that may not be true, my
Yes,
lord.
that is your submission, but we feel that is under compulsion. So, Mr. Das, now,
Lord, this penalty, first of all, my lord, my submission, my lord, subject to what your lordships
now
consider.
we can't set the clock back. The suspension period is already over. Everything is already over. Now the registration is also there. New registration is also there. You are pursuing with their courses. Now we can't set. the
I am also
clock
worried.
back.
I am also
Even
worried
though-
in at one aspect, my lord. I just express my mind, my lord, because they have already pursuing this thing. If only worry is that, my lord, before the single judge, there was a direction by the honorable single judge to place the grades scored by the petitioners or appellants in a seal cover. And in that direction, honorable single judge has asked that whatever the assignment, quizzes and end semester marks were there, you make the assessment and grade them whether they have passed or failed.
Yeah, that's it.
So my worry was that I don't, because that seal cover was, my lord, seen by the honorable single judge and returned to the respondents. I haven't seen that, what was there,
Whether you have passed or not.
whether I passed or not. If I passed there, whatever assessment was made, then I go through, my lord. Lordship need not to go into that aspect of the matter, whether mid-semester examination I appeared or not, whether I was forced to appear, not to appear.
Into consideration, sir. That has to be taken into consideration.
That is what the honorable single judge, in fact, recorded a finding that results, end semester results were not declared.
Which is that order?
Your lordship will find page 238 will be the relevant portion. Because I made a claim that I passed through even
Most of the semester segments of the evaluation process papers involved 8 semester accordingly. If the court requires. Evaluate the components where the petitioners have participated, like submission of quiz, etc., and record the marks scored in semester and grade each petitioner accordingly. So where is that assessment you have produced?
My lord, yes, my lord, I have produced it before the learned single judge, and learned single judge, there was a prayer made by the petitioner's side, and that prayer was not allowed. Verbally, they have made a prayer, and the learned single judge did not allow that. My lord, if I may just point out one. My lord, this order was passed before the fact brought to the notice of the court that these people have been participated in that alcoholic party, where they consumed alcohol and the activities which is followed thereafter. My lord, the fact.
10/6/2024 order.
My lord, this 10/6, yes, my lord. This was very initial at that time, my lord. The original
The
record.
reason for this, they challenged that punishment order.
Yes, my lord. So
So in that punishment order, these facts were very much there.
my lord, in the original records, what is there, how they've accepted before the disciplinary authority. At the very beginning, they've accepted their guilt. The fact that they've gone out of the campus and other facts who have been produced before the learned single judge at the time of the hearing as a part of original records. The court had perused that original records, and thereafter, in its own wisdom, decided, my lord, that not to give this benefit to them. But this was very initial finding, my lord. This is not, the
Why-
court on that time did not have the opportunity to look into the
Why
entire
my
fact, my
landlord
lord.
friend is,
That assessment,
My lord.
whether they were passed or not.
My lord, I have also not seen that assessment, my lord. I have just produced the copy and accordingly the respondent authorities have taken back. Because here, my lord, the power to declare grades is only with the Senate, my lord. And of IIT Guwahati, they have taken back the copy, my lord.
That in the seal cover.
Again, my
yes, my lord. If I pass through, then the hardship will not, or hurdle will not be there.
My
If
lord,
I fail,
Let us see.
Yes,
Then
yes,
Also, it would be very difficult. We just want.
yes,
to-
yes, 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 I appreciate, my lord. I appreciate.
During the pendency of the writ petition filed on behalf of the appellants. The next single judge on 10/6/2024 is directed the counsel for the IIT to evaluate the components, comma, wherein wherein the appellants had participated, comma, like submission of assessments, quiz, etc. And after reckoning the marks scored by the petitioner in the end semester examination to grade each of the appellants. And after recording the marks of the appellants in the end semester examination to grade each of the appellants accordingly on merits and furnish the same to this court in sealed cover. It appears that pursuant to the said direction of the learned single judge, the assessment was produced before the learned single judge on 24/6/2024. However, the same was returned to the counsel for the IIT. Full stop. Learned counsel for the IIT has submitted that the said assessment is not available with him at present. He takes some time to produce the same before this court in sealed cover. Time frame for is granted. List on
Tomorrow or day after tomorrow.
tomorrow or day after tomorrow. After
Let it be day after tomorrow, my lord.
After vacations, my lord.
List on date will not do the vacation. So and so.
22nd October.
One thing is sure, my lord, that the way, my lord, the penalty was imposed, my lord, that is absolutely wrong, my lord.
After all,
Whatever
these
I
are-
get,
After all, these are the IIT authorities, not the trained lawyers.
fine, my lord, but minimum
Yes.
requirement, my lord. Reasoned order, principles of natural justice, my lord. These are the
Yeah,
basic
they-
minimum aspects. And
We
evidence,
can't expect such accuracy from these.
no, not required. Evidence, you need to have some evidence against.
Evidence is that, Raj sir, you were there in the
No.
party. You remained, you
My-
stayed in the hotel.
My
What remains, sir?
Milord,
Evidence was
my
Raj.
presence in the party was not the allegation, Milord.
No, no,
allegation
your
is
presence
something-
In the party, you stayed without permission out of the campus. Or what others?
That card they have played repeatedly, Milord, everywhere. It's true, Milord. Much obliged, Milord. Lordship will kindly consider immediately.
Item 3.
Whether this, any counter affidavit is filed on behalf of the BTC?
Lordship, today I'm filing Lordship. I have already served copy Lordship. Yesterday we could not file because we are unable to serve copy.
Lordship, we will file a reply.
You already filed the
No,
reply?
we will be
No,
filing a,
supposed to file.
yeah.
Okay. The counter affidavit on behalf of the Bureau and Territorial Council is filed today only, however, the same is not in record. The office is directed to place the same on record. Then it council appearing for the petitioner seeks some time to file counter to the affidavit in reply filed on behalf of the Bodoland Territorial Council. Place this matter after 8 weeks.
Supplementary list, item 25.
May please. May please. Lordship, before my senior starts, Lordship, I have a preliminary objection to this petition. As this is a petition challenging 13(4). Existence of a alternative remedy under the Surface Act, section 17 is there, Lordship.
No problem. Lordship, after the bank respondent had issued a 13 notices under section 13(2) of the Surface Act, Lordship. And within 60 days, Lordship, the petitioners has filed their representation or objection as required under section 13(3)(a) of the Surface Act, Lordship. But the bank did not give any reply to the petitioner, Lordship, or it was never communicated that it is accepted or rejected, Lordship. My only point is this, Lordship, the provisions after Madhya Chemicals judgment in 2004, Lordship, for SCC page 311. Lordship, it was held by the apex court that there is some shortage in the legislation and that's why the provisions should be incorporated in section 13, Lordship, by that if a objection or representation is filed by the borrower, Lordship, that should be considered meaningfully, Lordship, and its acceptance or refusal should be communicated, Lordship. The word is sale, Lordship, under section 13(3)(a), Lordship. So, and it is in a ITC limited case, Lordship. The recent judgment 2018 Lordship, 2018, 515 SCC Lordship, page 99.
Yeah.
It has been held that this provision is mandatory and imperative, and the bank is bound to give the para कितने? लाओ ना para वाला दोनों को फाइल दो ना.
19, sir. 19, sir.
It starts from Lordship para 19 of the judgment, ITC. Lordship, may please to take up page 114 of the para 19.
114 of para.
19 Lordship. This is Lordship, Rule 3A. This is verbatim of this rule, section 13(3)(a), Lordship. Rule 3 of the rules requires the authorized officer, who is an officer specified by the Board of Directors of the secured creditor, to consider the representation and modify the notice of demand if satisfied of the need to do so in that regard. If the authorized officer comes to the conclusion that such representation or objection is not tenable or acceptable, he must communicate. He must communicate the reasons for non-acceptance of the representation or objection within 15 days. Then, Lordship, the next para, 20, Lordship. The Act and the rules. The Act and the rules provide for a locus ponitentiae. The borrower may raise an objection or make a representation of any nature that the creditor must consider, and if found not acceptable, may reject the same. Before proceeding to resort to any of the measures provided by section 13(4), for the moment I am posing your Lordship, until and unless the bank officer Lordship either rejects or modified or communicate the refusal Lordship, then only the bank can proceed for this taking symbolic position Lordship under section 13(4) of the, so otherwise not. Of the Act, the borrower may thus raise an objection against the proposed measures or make a representation explaining the circumstances in which he cannot discharge his liability and purpose reschedulement. This may result in out the proposed measures and may even result in renovation of the contract. Then, Lordship, para 21. Subsection 3A of the section 13 was introduced in the Act by the Parliament in pursuance of the following observation of the Court of in Mardia Chemicals, SCC page so and so. The purpose, clause 40, para 45 has been quoted of the Mardia Chemical. The purpose of servicing a notice upon the borrower under subsection 2 of section 13 of the Act is that a reply may be submitted by the borrower explaining the reasons as to why measures may or may not be taken under the subsection 4 of section.
They have raised the preliminary objection, please answer.
That's why Mardia Chemical has clarified it, Lordship, that until and unless the bank gives the reply to my objection.
Ultimately, the judgment of ITC Limited, the writ petition was dismissed.
No, Lordship.
2024. While holding that the petitioner, the debtor is not entitled for equitable relief under Article 226 and 136.
Lordship, in all of the other judgments, subsequent judgments, Lordship, this matter was Mardia Chemical judgment is by the 3 Honorable Apex Court judges, Lordship. All other judgments are by the division bench, Lordship.
That was Mardia Chemicals, that was a case, but here thereafter there is a categorical decision by the Supreme Court or various decisions that in these loan matters, The court should not exercise this power under Article 226.
Lordship, I am aware of the subsequent judgment,
The
Lordship.
latest
20
judgment of 3 judges bench also reiterated the same, sir.
No, Lordship, in those cases, Lordship, this 13(3)(a) provisions, Lordship,
Maybe, sir, you can very well challenge this ground also before the deputy tribunal. You can raise all these grounds, possible grounds, and is bound to consider
then,
it, sir.
Lordship, may be pleased to consider my prayer. Lordship, I am ready to file appeal under section 17 of this,
So
before
fine,
the,
sir.
only, Lordship, they had published the notice in the newspaper, Lordship.
You can very
So
well
only
challenge
for
that
15
notice
days, I may be protected, Lord. Only I'll file.
That is not,
Lordship,
we are not exercising a jurisdiction, we can't pass any interim order of this.
Lordship, ICC Limited, Lordship, it has been clearly held that this is
No
a
doubt, sir.
mandatory and imperative provisions which cannot be violated by the bank.
Raise this ground before the deprecatory tribunal, they will consider it, sir. Ultimately, it's a law of land. They'll consider
So
it, sir.
my apprehension is that they have already published the notice in the newspaper
Sir, you
for
can
sale.
very well challenge that action also.
Only, then
And
give,
the tribunal is
one give me, Lordship,
clothed with the power to
Lordship,
pass interim orders
kindly
also.
protect me for 1 week only, 1 week. I will file appeal.
2024 judgment, I have just
It's
seen
a
it.
bad practice, sir.
24 judgment. Para 15, para
That
30.
is there.
Apart from that, Lordship, I have other submission, just a minute.
Yeah,
Lordship, may I please to peruse the provisions of section 14(1) Roman 7. Lordship, as the Lordship, section 14, Lordship, provide that when a magistrate help is required along with the police, Lordship, for taking the actual physical position, the bank officer has to file an affidavit, Lordship, before the district magistrate. That it provides, Lordship, section 14, where the position of the secured asset is required to be taken by the secured creditor, or any of the secured asset is required to be sold or transferred by the secured creditor under the provisions of this act, the secured creditor may, for the purpose of taking possession of the control of any such secured assets, request in writing the chief metropolitan magistrate or the district magistrate within which jurisdiction any such a secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the chief metropolitan magistrate, or as the case may be the district magistrate, or such request being made to him, take possession of such asset and documents relating thereon, and forward such asset and documents to the secured creditor, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authorized officer of the secured creditor, declaring that, then your Lordship may come to Roman 7. The borrower has not made any repayment of the financial assistance, by Roman 7, sorry, Lordship. The objection or representation in reply to the notice received from the borrower has been considered by the secured creditor, and reasons for non-acceptance of such objection or representation had been communicated to the borrower. So my humble submission is that when the bank has to submit an affidavit before the district collector, Lordship, stating that the objector was representation is accepted or rejected, the police protection or magistrate protection cannot be given, Lordship.
Where is that? When they have given this?
Lordship.
Where the district magistrate or the chief judicial magistrate has given this protection?
They have already approached the Lordship district collector.
Consider it, sir. The district collector will consider it, whether this compliance is there, then only he'll issue a.
Lordship, my humble submission in this, if the provisions of section 13(3)(a) read with the section 14, Lordship, that there is a prohibition, Lordship, of further proceeding under section 13(4).
Sir, you can very well raise this ground before the DRT.
No, that's why I'm ready to minimum protection, or give me 1 week, Lordship, otherwise my party.
If we are not entertaining the petition, we are not supposed to pass. This may set a bad precedent, sir. This may set a bad precedent. On one hand, we are not entertaining on the ground of.
Lordship,
ability of-
actually, Lordship, I have, before initiation of successive proceeding, I have filed 5 numbers of title suit against the bank. It is, in that, Lordship, I have annexed the copy of the plain. I am entitled to record. There is no liability against me, Lordship.
That is for the, that DRT to decide, sir. We are not going to the bank, sir.
Then these provisions of section 13(3), all these things are nothing but a futile exercise.
Sir, that is the not direction. These are mandatory provisions and certainly the DRT. will take
Lordship,
into
in ITC case, it has been held repeatedly.
No doubt, sir. This is the position of law. And we are agreeing with it. We are not.
When Lordship, when the fundamental law is violated, the writ court has the jurisdiction to interfere. Lord.
Not in these matters, not in loan matters, because there is a complete mechanism, complete mechanism is provided and there in the Supreme Court is specifically said in such cases with the complete mechanism there, High Court should not exercise its discretion.
I am aware with those judgments,
Then,
Lordship.
sir, we are bound by that.
That Southern Bank Association case, 23 also, 24 also, it has been held by the apex court, Lordship, but
So then that is the binding on us.
no,
we can't
binding-
take any
that is
other
correct, Lordship, but the Madia Chemical decision is by a larger bench. Other decisions are by a division bench.
This is 3 judges bench, latest judgment 2024.
That is 24 is by the 3 judges. But section 3A, 13(3)(A) has not been dealt in that judgment.
They have they have said jahan pe once there is complete mechanism is there, High Court should not entertain it. That's all. Would you like to have an order on merits or with liberty?
See, I have one, Lordship, give me 1 week time, I'll file appeal.
That is not possible. Very sorry, sir.
Then, Lordship, I may be allowed to do it.
After attempting to argue the matter for quite some time, then it concept of the petitioner.
One may be recorded, petitioner assured that he will file or submitted that he will file appeal.
That
That may be mentioned.
on instructions has submitted that he wants to withdraw. This writ petitioner who seeks liberty for the petitioner to file an appeal before the Debt Recovery Tribunal under section 17 of the Securitization and Reconstruction of Financial Assets Act 2002. Full stop. Dismissed with liberty as played for.
Lovely.
Daily list for hearing item 5.
On the last occasion, Lordship, the Honorable Court directed me to appear in this case, Lordship.
Yeah, yeah.
So I have to go through the papers. It has been placed before me yesterday. So I need some time to go through the whole paper.
Till then, however, the Union of India may just make their stand clear where they were been asked to bring some instructions from the Union of India.
Yes, Mr. Chaudhary. 6/6/2024. 6/8/2000. Yes, ma'am. This affidavit is already filed.
I have not received a copy.
6/8/2024.
Maybe somewhere, but a soft copy will do the needful.
Provide your hard copy. Give him copy in today itself. Nikhil, Mr. Learned Advocate Chandra. Take some time to go through the brief. Mr. R.K.D. Chaudhary, Learned ASG, has submitted that he has already filed an
Next.
Affidavit, he has already filed required affidavit of 6/8/2024. The copy of the said affidavit will be supplied to the petitioner during the course of the day. List this matter after when
Prior to Durga Puja, prior to Puja vacation.
Puja vacation, after Puja vacation.
Deeply obliged, sir.
The learned AG will take some time to go through the.
However, we have received a copy of this new SOP from the Ministry of Health. It is the latest SOP of 3/9/2024,
So it is,
this month only.
it is covering all your grievances or what?
No, it gives a direction to the state government to implement various measures pertaining to gender reassignment
You
surgeries
supply
and
this-
other.
You supply this SOP?
Yes, I will share the soft copy.
Yeah, yeah.
Highly obliged, sir.
Item 6,
My lord, I have handed over the list of dates, my lord. Consciously, my lord, the brief facts, the stand of the affidavit, APSC, stand of the opposite parties, and the findings of the honorable single judge. I hope, my lord, it will be helpful to your lordship, my lord. And I have given a set of cases, my lord, showing, my lord,
Yes, Mr. Majumdar.
hello, only one aspect.
What are your latest instructions?
My instructions I have already placed. I'll make a.
That instructions.
make a
that's
submission,
very
my-
Strange.
No,
Yes, there are irregularities, there are.
my lord, let me be very, my lord, let me be very.
Substantial nature, but you cancel it, we are.
No,
not going
my
to
no.
cancel it.
My lord,
Then
my lord,
last time we.
My lord, he
warned
lost
you
me.
that we are going to make certain.
I have come
accommodations
prepared,
that
my
the
lord.
government needs.
I have come prepared. My lord, my submissions are like this. Your lordship, on the previous occasion, directed us to bring instruction, lordship will kindly check the order, my lord, to bring an instruction as to whether we still like to protect the select list or not. We specifically said our instruction very
We are
specific.
not going to.
We are not going.
Sir.
Now that since the matter is before your lordship, we cannot my lord, undertake a parallel proceeding and say that no, we will not go ahead with the, we will not appoint. If your lordship is insisting on the matter, you will lordship decide. But I will only read one judgment to show, my lord, in such cases, in a case where a question arises as to whether in view of certain irregularities found in the selection process, whether to protect the select list or not, there is one judgment where I would like to lay on a few paragraphs. And this is 2020. 2021 4 is 631, madam. Six, 3, 1. Para 2, 20, 33, 57, and 48. I am relying, madam. Para 2, 33, 48, and 57.
Para 2, yes.
Yes.
Leave.
Madam. This judgment visits a familiar conundrum in service jurisprudence. The constitutional values which under
But this. Yeah, it's a leave granted. Okay, fine.
Leave granted, first paragraph, second paragraph. This judgment visits a familiar conundrum in service jurisprudence. The constitutional values which undergird Articles 14 and 16 mandate that selection processes conducted by public authorities to make recruitments to have to be fair, transparent, and accountable. All too often, human fallibility and foibles intrude into the selection process. Selection involves intense competition, and there is no dearth of individuals who try and bend the rules to gain an unfair leap in the race. Irregularities in the process give rise to misgivings over whether the process has denied equal access to all persons. The sanctity of the selection process comes under a cloud. The detection of an individual wrongdoing by candidates may result in action being taken to exclude those whose credentials or performance is tainted. But when the entire process is tainted, the authority in charge of conducting it may decide to cancel the selection as a whole. Judicial review is then involved to challenge the decision to cancel the entire process. The guiding principles have evolved over the past 5 decades as new challenges emerged and novel attempts to suborn the legitimacy of recruitment process have come to the fore. Delhi High Court in the present case upheld the view of the Central Administrative Tribunal that the cancellation of the entire process was invalid, but it confined the relief to 6 candidates who had moved the proceeding before the tribunal in the first instance. Like other cases of its genre, this batch of appeals calls the court to balance 2 competing considerations: the need to preserve public confidence in and the sanctity of selection to public posts, and requirement of observing fairness to candidates who invest time and resources in attempting to clear through a selection. Both these considerations have a constitutional foundation going beyond service and administrative law principles. The issue has traveled to the court for resolution, and the path ahead requires us to revisit and evolve the law on the subject. Then, well, there were some reports about there was a complaint of irregularities in the selection process. Then I'm reading, well, para 33. This is under the caption F, the position in law. In deciding this batch of SLPs, we need not reinvent the wheel. Over the last 5 decades,
23.
33, my lord.
33.
33.
35.
33, my lord, I'm reading first.
33.
33, my lord.
Okay, read.
Madam.
Mr. Chandrasekhar.
33 in the SCC says, in deciding this batch of SLPs.
So this is 35. The position of law.
Yes, madam, it's not, madam, SCC, I am holding, today.
We have this.
I'm not correct, your lordship is correct, madam. I'm reading from Supreme today, madam. In deciding this batch of SLPs, we need not reinvent the wheel. Over the last 5 decades, several decisions of this court have dealt with the fundamental issue of when the process of an examination can stand vitiated. Essentially, the answer to the issue turns upon whether the irregularities in the process have taken place at a systemic level so as to vitiate the sanctity of the process. There are cases which border upon or cross over into the domain of fraud, as a result of which the credibility and legitimacy of the process is denuded. This constitutes on one end of the spectrum where the authority conducting the examination or convening the selection process comes to the conclusion that as a result of supervening event of circumstances, the process has lost its legitimacy, leaving no option but to cancel it in its entirety. Where a decision along those lines is taken, it does not turn upon a fact-finding exercise into individual acts involving the use of malpractices or unfair means. Where a recourse to unfair means has taken place on a systemic scale, it may be difficult to segregate the tainted from the untainted principal participants in the process. Large-scale irregularities, including those which have the effect of denying equal access to similarly circumstanced candidates, are suggestive of a malaise which has eroded the credibility of the process. At the end of the spectrum are cases where some of the participants in the process who appear at the examination or selection test are guilty of irregularities. In such a case, it may well be possible to segregate persons who are guilty of wrongdoing from others who have adhered to the rules and to exclude the former from the process. In such a case, who are innocent of wrongdoing should not pay a price for those who are actually found to be involved in irregularities. By segregating the wrongdoers, the selection of untainted candidates can be allowed to pass muster by taking the selection process to its logical conclusion. This is not a mere matter of administrative procedure, but as a principle of service jurisprudence, it finds embodiment in the constitutional duty by which public bodies have to act fairly and reasonably. A fair, reasonable process of selection to posts subject to the norm of equality of opportunity under Article 16(1) is a constitutional requirement. A fair and reasonable process is a fundamental requirement of Article 14 as well. Where the requirement to public employment stands vitiated as a consequence of systemic fraud or irregularity, the entire process becomes illegitimate. On the other hand, where it is possible to segregate persons who have indulged in malpractices and to penalize them for their wrongdoing, it would be unfair to impose the burden of their wrongdoing on those who are free from paying. To treat innocent and wrongdoers equally by subjecting the former to the consequences of the cancellation of the entire process would be contrary to Article 14, because unequal would then be treated equally. The requirement that a public body must act in a fair and reasonable terms animates the entire process of selection. The decisions of the recruiting body are hence subject to judicial control, subject to the settled principle that the recruiting authority must have a pleasure of discretion to take decisions in accordance with law, which are best suited to preserve the sanctity of the process. Now it is in the backdrop of these principles that it becomes appropriate to advert to the precedents of this court, which hold field. Now, various judgments has been referred to. Now, Lordship may kindly see page 50, para 57 in this judgment manner. Possibly it may differ with the paragraph your Lordship is holding.
Yes.
But 57 here starts with recruitment to public services must command public confidence. Recruitment to public services must command public confidence. It will be towards the end. Lastly, the only Supreme Court is mentioned in para 60 for the above reasons we order and direct. Just 2 paragraphs above that matter.
It's para 60. The recruitment to public services must command public confidence. Persons who are required to intended this.
My lord. My lord, yes. Recruitment to public services must command public confidence. Persons who are recruited are intended to fulfill public functions associated with the functioning of the government. Where the entire process is found to be flawed, its cancellation may undoubtedly cause hardship to a few who may not specifically be found to be involved in wrongdoing. But that is not sufficient to nullify the ultimate decision to cancel an examination where the nature of the wrongdoing cuts through the entire process so as to seriously impinge upon the legitimacy of the examinations which have been held for recruitment. Both the High Court and the Tribunal have, in our view, erred in laying exclusive focus on the report of the second committee, which was confined to the issue of impersonation. The report of the second committee is only one facet of the matter. The Deputy Chief Minister was justified in going beyond it and ultimately recommending that the entire process should be cancelled on the basis of the findings which were arrived at in the report of the first committee. Those findings do not stand obliterated, nor has the tribunal found any fault with those findings. In this view of the matter, both the judgments of the tribunal and the High Court are unsustainable. Well, here my submissions will be like this manner. Lordship has seen so far as and I submitted a report also on the basis of the documents supplied by the Public Service Commission manner. If your Lordship goes to the 3-page manner, sort of a report manner, it was prepared by me on the basis of the documents furnished by them.
This is not a report.
But it says it's not sealed, my lord, it's sealed and
That you have compared the marks and all.
my lord. I made the compilation basically on the basis of marks furnished by them, the documents furnished by them. There, if your Lordship goes to the remarks column, my lord,
Just-
all
Just. Let us find. ये तो इसी के
My lord, it is in the tabular form, my lord. On top, it is written list of candidates showing marks in the merit list and in the mark sheet. I think that is the one, my lord.
list of candidates.
My lord,
marks in
my
the
lord.
merit and in the mark sheet.
My lord. My lord, lordship will find in the fourth column, original marks in mark sheet, and fifth column is marks shown in the merit list. Now, there is difference in the marks shown in the marks,
That is
shown
what-
in the
yes.
of everyone. Now, in one or two cases, it is found like similar serial number 3. Although the marks in both the column are similar, but then in remarks column, lordship will find I have written that overwriting in the general bearing. And your lordship will find in the remarks column, it has been mentioned that in the case of all the persons, there are differences in the marks. And in respect of serial number 3 also, there is a overwriting. So, my lord, what it
Except this serial number 3 in all in case of all the other applicants,
my lord,
the marks have been changed.
changed, my lord, it shows that the mark sheet at least has been tampered with. My lord, before that, what has happened and who has done all these things are possibly subject to any other investigation and the criminal case that has been registered. But it appears that, my lord, the mark sheet is tampered with and it has lost its sanctity. And that is why, my lord, we have obtained instruction and the government has specifically said that,
You were supposed to
my lord,
satisfy
No, my
us
lord.
that why the state government is
my
not
lord,
taking
my
any
lord,
action.
there are two difficulties why we could not take a decision. First of all, your lordship only directed us to obtain instruction whether we want to still protect it or we said we don't want to protect. Secondly, my lord, when the matter is before your lordship, we cannot take a decision, my lord, simultaneously and my lord, parallelly. Thirdly, my lord, there is one difficulty as my learned friend has argued the other day. My learned friend tries to say that if there are candidates in respect of whom marks are either not increased or it is reduced, based on their original marks, if they are selected, they can be appointed.
But here now
My lord, this in
there are all 56 candidates
my lord,
and almost marks of every candidate has been changed except one.
absolutely, my lord. That is why, my lord, my submission is it has lost its sanctity.
Besides this, I'm just pointing out, there is a tabulation form. I think it was given by APC. We have seen that. The tabulation form, your lordship will find that there is no signature of the persons who have signed it. And they have added marks for experience.
So this is the fact.
Yes.
This is the fact which they have mentioned.
No, additionally also that tabulation forms, who has signed it, even the correction,
That's
who
another
has signed
thing.
it.
Ultimately,
Entire process
the
is
marks
kind
were
of,
changed. That's
Yes.
all.
yes.
That was the.
This is apparent.
Yes, Mr. Very hard case.
My lord, my submission would be either we await the criminal investigation which is going on.
How many years it will take?
Number two, my lord, ignoring the aberrations, going by the original mark,
Original marks.
let my lord, or a fresh interview. These are the three options.
The fresh, So the fresh would be the best option.
Fresh
because-
interview, that in my humble submission, that would be the last objection, last option, my lord. Now, why in my humble submission, why your lordship should adopt the number 2? Now, let us go by my learned friend's own assessment.
Yeah.
Please come to that, my lord.
Yes,
The serial number 1, Naina Bhuya, her only fault is she secured the highest mark. My learned friend says there should be fresh selection. Why? 2 marks has been deducted.
that's why she's above the, on the top.
No, my lord, as far as she is concerned, there is nothing wrong. I'm just indicating, my lord. Now, number 2, 3 marks added, 2 marks added in general bearing, discard him. Now, regarding serial number 3, my lord, there is no change. Regarding serial number 4, admittedly has been, there is a overwriting and added, some marks has been added. Therefore, discard him. Serial number 5, 3 marks deducted. Why he should be penalized, my lord? Similarly, serial number 4, 7, serial number 8, serial number 9, serial number 10, their marks were reduced. Then serial number 11 reduced, serial number 12 reduced, serial number 13 reduced, serial number 14 reduced, serial number 15 reduced, serial number 16 reduced.
Up to 23,
Yes,
all reduced.
my lord. Your lordship knows, my lord, that Punjab case, the Honorable Supreme Court never said lock, stock and barrel, set them off. No. A 3 judges committee of the Punjab and Haryana High Court was constituted to go into the irregularities. Only thereafter a decision was taken. Now, going by my learned friend's own assessment, my lord, now what is wrong in this? Yes, there are wrong. I'm not saying no. So why there should be a wholesale disturbance, my lord? There are cases which can be saved. And that is what my lord Honorable Supreme Court has, and in fact, the judgment which my learned friend read, there itself it has said.
So what is the authenticity that the original marks are also awarded?
That is nobody's case, my lord.
Nobody's
That
case,
is, that is nobody's case.
can be, the impression can be always
No, my lord.
gathered.
It
that
appears,
that is so.
if at all any irregularity has taken place,
Yeah.
it has taken place post-interview. The interview board has given their marks, which appears on the original marks in the mark sheet. Now, if at all we proceed on the basis that some tempering was done, it is the 5th column. Now, by the 5th column, whomsoever, yes, my lord, it has to be your lordship satisfaction. I am only making my submission. End of the day, your lordship will have to be satisfied that yes, here is a case. This is what we should do. This is what we should not do. But my humble submission is, my lord, going by the preponderance of the judicial view of the Supreme Court, only in case of a mass copying, my lord, where Supreme Court has said n massa cancellation should be done. Otherwise, Supreme Court has not. That Punjab case was the worst case, my lord.
In
Where
this
Supreme
case
Court never
also they
did
have
that.
said that if some, the persons who are not guilty can be segregated.
Exactly, my lord. I'm just relying on the judgment of the Supreme Court, my lord, Union of India versus Rajesh, that 2003 7 SCC 285. 2003 7 SCC 285, paragraph 6. Two, 8, 5. What is it?
Rajesh versus?
Union of India versus Rajesh, my lord. Rajesh PU, it's a very long name, my lord.
In my bunch of case laws, my lord, I think it is flag E.
You have?
Flag E, my lord. Flag E.
Thanks.
P. Rajesh PU.
Page 289, my lord. On a careful consideration of the contentions on the either side, in the light of the materials brought on record, including the relevant portion of the report said to have been submitted by the special committee constituted for the purpose of inquiring into irregularities, if any, in the selection of candidates filed on our direction, which report itself seems to have been also produced for perusal of the High Court. There appears to be no scope for any legitimate grievance against the decision rendered by the High Court. There seems to be no serious grievance of any malpractice as such in the process of written examination, either by the candidate or by those who actually conducted them. If the board itself decided to dictate the question on a loudspeaker in English and none of the participants had any grievance in understanding them or answering them, there is no justification to surmise at a later stage that time lapse in dictating them different language left any room or scope for candidate to discuss among them the possible answers. The posting of invigilators for every 10 candidate would belie any such assumption. Even that apart, the special committee constitution does not appear to have condemned that part of the selection process relating to conduct of written examination itself, except noticing on the certain infirmities only in the matter of evaluation of the answer sheets with reference to correct answers and allotment of marks to the answers of some of the questions. In addition, it appears that this special committee has extensively scrutinized and reviewed the situation by reevaluating the answer sheets of all the 134 as well as 184 unsuccessful candidates, and ultimately found that except 31 candidates found to have been declared successful, though they were not really entitled to be so declared successful and selected for appointment, there was no infirmity whatsoever in the selection of the other successful candidates than the 31, whomsoever in the selection of other successful candidates identified by the special committee. In the light of the above, and in absence of any specific or categorical finding supported by any concrete and relevant material, that widespread infirmities of an all-pervasive nature, which could really be said to have undermined the very process itself in its entirety or as a whole, and it was impossible to weed out the beneficiaries of one or other of the irregularities or illegalities, if any. There was hardly any justification in law to deny appointment to other selected candidates whose selections were found to be in any manner vitiated for any one or other reason. Applying a unilaterally rigid and arbitrary standard to cancel entirety of the selection despite the firm and positive information that except 31 of such selected candidates, no infirmity could be found with reference to others, is nothing but total disregard of relevancies and allowing to be carried away by irrelevancies, giving a complete go-by to the contextual consideration, throwing to the wind the principle of proportionality in going further than what was strictly and reasonably to meet the situation. In short, the competent authority completely misdirected itself in taking such an extreme and unreasonable decision of cancelling the entirety of selection, wholly unwarranted and unnecessary, even on factual situation found to, and totally in excess of the nature and gravity was what at stake, thereby virtually rendering such decision to be irrational.
What are the
I-
option? You suggested 3 options.
Yes.
You consider.
One final submission, Milord.
Fine.
Even in this case, there was a committee which was constituted and committee had given the findings. In Milord, that Punjab case also, there was a committee of the 3 honorable judges. But in this case, my lord, there is no committee, no nothing.
But
I leave it to the wisdom of my learned friend, learned additional advocate general of the state, my lord. But my lord, even his report does not, suggest something of an overwhelming nature to take a view that whole basket is rotten. Therefore, in my humble submission, my lord, these appointments which can be saved and attempts to
and
be made to
the
save.
fact remains that till date appointments have not been.
No.
Well, only 2 aspects of the matter. I'm just like to point, it's all right, my lord. Everything is good. I'm just pointing out, my lord, that that rule under which they were selected, the rule is, my lord, on the face of it, it shows 50% marks for the interview.
Sir, on the last day, when we asked you, you said, "Ki I am not on that point, that the
is
selection
there.
can't be made on the basis of Viva Voce." You were
No,
on that day, and if you want to
No,
argue
no,
on
I'm
that,
just pointing out, Malad, that, because that's
no,
a
no,
guideline.
because now
That I understand the entire process.
we'll have to observe this, that you are not challenging that part of the judgment where the learned single.
There are up to number of Supreme Court judgment, where Supreme Court has said based on interview also it can be done. Starting from Anjar Ahmed, so many cases are there.
That's right, but that's why only you are not challenging that. We are simply looking into this part regarding irregularity committed by the whatever the.
My lord, my lord, so there is one aspect which I think the state government should seriously consider. My lord, more mark is given to the member of the APSC than to the expert in the subject. I think that should be reversed.
More marks were given.
My lord, out of the interview component, the subject expert has lesser component. The member of the APSC who is in the selection board, he has more marks. I think that should be reversed. Because it is the relevant subject which matters.
Malad, there are guidelines, Malad, your lordship has to, Malad,
And my learned friend in his report
see, Malad, that
has given us, referred to a judgment of the High Court that this is only a guideline. I think my learned friend should use his good office and write to the government. You amend this rule. I used to do, my lord. Only, I mean, making argument in court will not do, my lord.
Yes.
Malad, that rule itself is a guidelines only. Malad.
They should write.
I consider my friend's suggestion.
No, of course.
We often discuss with him because earlier also he had the same office and at times we agree on certain points.
No, my lord, in fact, it
At
should be
times,
done.
what do you mean by at
No,
times?
on other issues, we discuss on other issues also.
No, my lord, end of the day, end of.
Act as an additional evidence.
No, my lord, end of the day, when we see something which is not in public interest, we should point out.
No, no.
And at time it matters, my
It's a
lord.
duty of
Yes,
everybody's duty.
Yes.
Absolutely.
Has to be. Thank you, sir.
Diploma.
Obliged. Malad, I have given the detailed facts for your lordship.
Item 7.
If I may, your lordships. Lordships, if you would kindly allow this matter to be heard on some other day, my senior for the petitioner is currently arguing a matter in front of class, courtroom number 10.
Who are us to allow this? Who are us to allow this?
Yes, Lordship.
Allow us
You would
to.
kindly allow.
It is for you
matter
to argue or not to argue. Where is the, where our permission is required for that?
Yes, Lordship. If
That's
you
what-
would kindly allow
yes.
this matter. Thank you.
Citizen.
Item 8.
Please, the lordship. This matter. Constitutional validity of Municipality Act, which is amended, that is under challenge before your lordship.
The wide amendment, what they have introduced.
They have introduced the education qualification.
Education.
On the face of it, my lord, absolutely, education may be important, definitely important, but for the election purpose, there is a only thing which I'll,
So you argued earlier on.
my brother argued the matter. Initially, I argued, I was not here. So
We posed a question to him.
regarding that Jyoti Basu case, whether right to vote and right to contest is a fundamental right. Of course, it's not a fundamental right. It's a constitutional right. But
Constitutional.
it is a constitutional right. I'll show it to your lordship. I have checked that.
Okay, even though if it is a constitutional.
So my argument is not on the basis that it directly violates the fundamental right. That's why it should be discarded or it should be set aside. I am saying it's a constitutional right, but under Article 14, because it being a discriminatory law and also being an arbitrary, I'll show you that is what my entire argument will be, that it's discriminatory. Why, lordship? Because in the municipality committee, MP and MLA also, they are ex-officio member. Now for those ex-officio member, there is no requirement of educational qualification. Now they can participate in entire process as this commissioner will participate.
Not entire.
My lord, they
There are
can
certain
frame the,
restrictions.
they can
They
frame the
can't
rule
vote.
also.
They can't vote in certain circumstances. They only has to participate. That is their role is limited.
Correct.
That is.
But on that aspect, I'll show it to lordship, even for the making of rule also, and even for taking revenue decision, because what the government has filed the affidavit, they said what is their objective behind this amendment. The objective is that one should know revenue, one should have the knowledge of different aspects. Now, all those for that, there is a constitutional provision only, Article 243R, where says that for municipality, there will be a person with a skilled knowledge. Now, the knowledge is not a criteria for election purpose, not only the knowledge. There has to be a proper representation also. Now, what my lord is saying that MP and MLA, my point is, if their education is not required, it directly hit the discrimination part because there is no intelligible difference here. The objective, my lord.
Members by the virtue of the statutory provisions and not by election.
But ultimately
It's
they
a separate class.
ultimately-
It's a separate class.
ultimately they're elected body only. They're elected body. Now their election is
Elected
also
under different.
different election,
act or
absolutely.
something else.
But that is what I'm saying, that not whether the object of the act, if it is to be having a committee with all the class 12 pass people, then why there is an ex officio member of MPA, MLA who are not having the same qualification?
Suppose out of there are 5 members, one person is not having that.
So
qualification
that
for
objective has not, that they'll have to show it, that why there is a differentiation, why there is a discrimination,
The
madam.
whole objective is not to, can't be said to be frustrated with this.
And on that is on the issue of discrimination, my lord, Article 14, I'm not only on the issue of discrimination, that is one of the point. But on the arbitrariness also, I'll have to show it to your lordship whether it is arbitrary or not. Arbitrary because there will be my ground on the arbitrariness. Of course, my lord, education, the moment education comes, it comes in the mind that it should be there. Education should be there, but for till date, why Parliament has not adopted a law for bringing education for election of an MP?
Because
For-
of us. Because of us.
My lord.
We have never raised this demand.
So question
We are
is,
the voters, we have never.
panchayat and
We
municipality.
we always elect a person on the basis of whatever the caste, creed and something.
No,
the
that is-
thing into the education.
My lord, but
qualification of a person. We are
understanding is,
responsible
the
for that.
understanding is, my lord, what I have, my limited understanding, what I have seen from the judgments on the democracy, part of democracy, more than education, it should be the higher moral values and proper representation of the people. Now, there can be uneducated person also, if there can be educated person also. So there will be lesser representation of the uneducated class if the privileged class always gets the advantage. That is why the concept of democracy comes where a higher moral is more important than the education. My lord,
Both are
equally
important.
important, but
Both are equally.
there should be representation, and that being the reason, it has not
Both
been
are
yet brought in.
equally- both are equally.
My lord, I'll have to give on the arbitrariness, I'll have to place some. Yes, my lord, not even, I'll just. My lord, may kindly want to see the. Municipal. Malad, I'll just show the firstly on.
First of all, you just satisfy us that it's a contesting election is a constitutional right.
Yes, Malad. Malad, on that, I'll show the judgment also. Rajbala, issue of Rajbala, my lord will know in the Rajasthan High Court. There the issue arose because in the Panchayat election, they have got same educational criteria, matriculation. That was under challenge. Now, Honorable Supreme Court has stated that it is not on the basis of arbitrariness because it relied on the McDowell's case. And because its arbitrariness cannot be itself violative of Article 14, that's why court said that we'll not go into that aspect. But there in that case, court has stated that it is not a fundamental right to vote and right to contest. It's a
Right to
constitutional.
vote and right to contest.
Both.
Right to vote is certainly a.
No, my lord, even that also aspect has been said to be, it's a constitutional right. So it's a constitutional right. But if the matter could have ended there only, that it's a constitutional right, it's not a fundamental right, then there was no requirement for the Honorable Supreme Court to go to the extent of deciding whether arbitrariness can violate Article 14 and whether this amended section can be violative of Article 14.
That Rajbala case, the provision has been upheld.
That is why, my lord, merely because there is a constitutional, merely because this right to contest election is not a fundamental right, that doesn't mean it being a constitutional right, it cannot be violative of Article 14. If there is a discrimination, if there is an arbitrariness, it violates Article 14.
What is that judgment?
My lord, Rajbala judgment, first of all, I'll try to show. Rajbala, because it has been overruled. McDowell has been overruled by Saira Banu on the basis of that aspect, whether arbitrariness can be treated to be violative of Article 14 or not. On that aspect, it has been overruled. Rajbala.
Rajbala overruled.
Overruled by Saira Banu and the triple talaq case, as well as
Sure.
yes, my lord. My lord, Rajbala will be 2016. 2 SCC 445. In fact, on the last occasion when I appeared in 2022, I was asked to prepare a court note for all the judgment. I had prepared it. I can pass it over to your lordship so that it will be
Sure,
convenient for your
sure,
lordship. Hello? Here I have placed the particular paras where the court has relied and how this has been overruled, Rajwala case.
It is implied this overruled or specifically?
Specific overrule. McDowell has been relied upon and McDowell is overruled and accordingly court said that even.
So McDowell has been reversed, therefore you are saying.
No, my lord, there is a categorical observation by the court. I'll show it. I'll directly take your lordship to the Rajbala judgment itself, first of all. Where that particular question where lordship has pointed out, I'll just show that fact.
2016 2 SCC 445 is the Rajbala judgment.
Yeah.
Yes, my lord. Here from just 64 from 64. It starts the finding from the where it is not permissible for to declare. This is Rajbala. Rajbala, there is a finding. I'll show the Saira Banu case where Rajbala has been overruled.
Rajbala shows the first finding of the Rajbala. Sir.
Finding. Para 64, that will be 481 page number.
Yes.
May I read, my lord? From the above extract from McDowell and company case, it is clear that the courts in this country do not undertake the task of declaring a piece of legislation unconstitutional on the ground that legislation is arbitrary. Since such an exercise implies a value judgment and courts do not examine the wisdom of legislative choice unless the legislation is otherwise violative of some specific provision of the Constitution. To undertake such an examination would amount to virtually importing the doctrine of substantive due process employed by the American Supreme Court at an earlier point of time while examining the constitutionality of Indian legislation. As pointed out in the above extract, even in the United States, the doctrine is currently of doubtful legitimacy. This court long ago, back in S. Krishna versus State of Madras, declared that the doctrine of due process has no application under the Indian Constitution. As pointed out by Frankfurter J, arbitrariness become a mantra. For the above reason, we are of the opinion that it is not permissible for this court to declare a statute unconstitutional on the ground that it is arbitrary. Now, this finding of Rajwala, only on the basis of this finding, court said that the amendment which has been brought with respect to violation of Article 14 because of introduction of the education qualification for Panchayat election in Rajasthan, court said that we cannot enter into this aspect.
It's not Rajasthan in Haryana.
Sorry, my lord, it's Haryana. Rajasthan is the second issue which is pending before Supreme Court. It's Haryana. Then I will come to lordship. The judgment of Saira Banu, that's a triple talaq judgment where this issue has been discussed, and specifically I'll show the paragraph where this Rajbala judgment has been overruled. That is in page 88. Para 99, the Saira Banu case. It's 2017 9 SSC 1.
Yes.
2017 9 SSC 1, page 97, para 99.
Yeah.
It says, however, in the state of Bihar versus Bihar distillery, in the state of MP versus Rakos Koli, in Rajbala versus state of Haryana, and Binoy Vishwam versus Union of India SSC, so and so, was McDowell was read as being an absolute bar to the use of arbitrariness as a tool to strike down legislation under Article 14. As has been noted by us earlier in this judgment, McDowell itself is per inquirim, not having noticed several judgments of benches of equal or higher strength, its reasoning even otherwise being flawed. The judgment following McDowell's are therefore no longer good law. So that is how Rajbala had been overruled.
And which is the matter pending before the
Supreme Court in the Rajasthan also they brought a similar law, but later on Rajasthan has repealed that provision.
where is that Rajasthan judgment?
This is at I will just place the order. It's a very small order because they have relied on the Rajwala itself. That they have sent it to. এটা হাইকোর্ট এটা সুপ্রিম কোর্ট But I have given the High Court judgment that relied on the Rajbala Haryana case. And then the Supreme Court order where the leave was granted and it is still pending, though. Otherwise, it's an academic question which is there. Now the effective issue is pending here before your lordship. This law is no more there in Rajasthan now. High Court.
Yes.
Yes, if my lord is satisfied on the point that whether right to contest election can have a arbitrariness.
Then we'll have to ponder over it and then have to arrive at a satisfaction. You please answer.
No, because
Satisfied, you can't say that they are.
no,
satisfied or not.
I was on the point, if lordship want to see on the issue of right to vote and right to contest, whether it was discussed in Rajwala, that I can point it out.
Yeah,
to
that
your
is
lordship.
there. We have seen that.
Para 19,
That is there.
Jyoti Vasu has been discussed. So after taking into account that aspect, court has gone into the aspect of Article
The court
40.
has also, in Rajbala, the court has also taken into consideration the importance of education.
Yes,
and
Lordship.
how that is there.
Yes, Lordship.
That part has not been overruled.
That part has not been touched,
That part has not been
But-
overruled. Na?
but ultimately whether,
Only that a law can be set aside on the basis of the, on the ground of arbitrary.
Yes, Lord.
That part has been.
So I will be arguing on the point whether today now amendment, this has brought any arbitrariness, whether it has created any arbitrariness that, and discrimination is the main point, Lordship. Discrimination with respect to
Vis-a-vis the
MP
elected
MLA.
MLA.
Yes, my lord.
Fine.
Because I'll show whether the power has been,
Discrimination, the problem is the discrimination always in between two equal classes.
absolutely, Lordship.
So the MP MLA elected and so and this panchayat representatives or municipal corporators to constitute a equal class or a separate class.
If they are brought into the same category by this act,
Category is altogether different.
Lordship.
In many cases, the ex officio secretary is also a member of a committee who is a government officer.
But
There is a class, but he is also discharging the same duties or
Absolutely.
whatever it may be.
ultimately, respondent will also have to show it that why that ex officio member does not have a requirement of education, but these commissioners need to have the requirement. This requirement, because it's a constitutional provision where it says that they can have a skilled person. The skilled person anyways have the knowledge. So that is how, whether it will be treated to be arbitrary, because putting education as a bar, whether it can directly affect the democratic this thing representation or not. I'll just show, may I show that Municipality Act where section ex officio members and what the access,
That is there, sir.
yes, and the
It is
power
there.
lordship said they don't have a right to.
Representative, member of legislative assembly and member of parliament are the members by their whatever the position they are holding. And except in the vote of no confidence, they can't vote. That is there. So
My lord,
don't
I
know,
think
about Assam law.
Subject
But
to
so far
correction,
as
my
we
lord,
know,
I think
Rajasthan law.
section 20 white board has the power to remove the chairman and board includes the MP MLA.
That is, there is a separate provision for that, sir.
Section 28 is there, my lord. Section
Supreme Court
28.
Judgment is also there. That is on Ramesh Mehta versus something, that Supreme Court judgment is also there. That is in relation to Rajasthan. I am not aware of that.
My lord.
The exact position here.
Here, my lord, because if I have to read from the act, section 11 says,
Okay.
section 11 says the board shall constitute a municipality act. As নতুন কোন আছে নি? হবো, এখানে দিও।
New one or
The amendment may not be there, but that is not what I'll be showing, Lordship. I'll be showing that section 11 definition that will be there. Section 11 says the number of
Section 11?
11 of the Assam Municipal Act. 1956.
Yeah.
It says the number of commissioner of each municipal board. So the board will constitute the, if you, my lordship said, 3AB. The member of Council of States resist, as elected within the municipal area. No, the 3A, the members of the House of the People and Legislative Assembly of the state representing the constituencies which comprise fully or partly in municipal area shall be ex officio member of the board. They are member of the board. Now, if your lordship see page, section 28. Section 28 is removal of chairman and vice chairman. And in fact, must have missed the judgment. I can show you to your lordship also. There are judgment of this honorable court where there is a question whether these ex officio members are part of the board or not. And court, I will have to refresh that memory because I can show it to your lordship because there is a judgment. And that's how I have found out. If your lordship,
What's the judgment?
I'll just have to place the judgment. I can.
What it says?
It says that subject to correction because my lord, I have not checked it today because I remember the judgment.
Okay.
It says that even commission, these ex officio members also can be part of the board while removing the chairman and vice chairman.
Then you go to one Supreme Court judgment that is there. that Ramesh Mehta
My lord.
versus State of Rajasthan or something.
My lord.
That Supreme Court judgment year, I don't know, it's, I think so. 2000, prior to 2010 or something, we go through it. That deals with this right of the ex officio members in removal of that person or not. That is no confidence motion, etc.
But
That they have recognized that.
there will be, but as 28 says, that there will be, might be conflict because here there might be a separate judgment on that aspect. I'll just place that, I'll
Go
satisfy on
through
that.
that judgment.
Yes, my lord, I'll check that judgment. But I'll just show 28. It says an elected chairman or vice chairman may be removed from his office by a resolution of the board. The board, my lord, have seen that ex officio members are part of the board, and this same board has a power to remove the chairman and vice chairman. And I will show, in fact, for setting the rules also, this board has the same power. And there is no proviso or any exclusion of the ex officio member in any of the activity of the board.
So you mean to say that the member of house, House of People and Legislative Assembly,
They exercise the same power.
are they commissioners?
They are treated to be member of the board.
Ex officio members, not the commissioners.
But ultimately, they are taking all the decision together because there is no
And
differentiation.
Here, the removal of the chairman, elected chairman may be removed, his office by resolution of board in favor of, which not less than half of whole of the commissioners.
So that is why I need to show that judgment. Even the ex officio members have been treated as a commissioner,
Okay,
part of the
shows-
board.
Shows.
Yes, Lordship, I'll place it tomorrow, Lordship.
Tomorrow, or you go through that Ramesh Mehta judgment also.
Yes, because
Yes, Ramesh Mehta versus Savanjal Singh B.
citation.
2004 5 SCC. 2004 5 SCC 409.
If possible, my lord, may I keep it, I'll go to it tomorrow because I don't stay here, my lord. If otherwise I can appear virtually. Yeah, so.
Go through this judgment also and
I'll place that my judgment also. I'll go to the judgment.
yes, Mr. Segia.
Yes, maybe tomorrow or after vacation, whatever is coming. But
What arms you have in your ammunition?
I have this lordship, Javed and others versus State of
Haryana.
Haryana.
Haryana that.
Yes, very categorical, paragraph
Three,
22.
that
Paragraph
more
20.
than 2 children at a particular date.
Yes, in that case, there is a reference of paragraph 22, where it says it is neither a fundamental right nor a common law right, but it is a right originating from the statute.
The Jyoti Basu case that. was
Yes,
there.
and finally, it is also saying there is nothing wrong in the same set which confers the right to contest an election, also to provide the necessary qualification without which a person cannot offer his candidature. It has upheld the additional of qualification, and it has rooted from Article 243V.
Stop to video vacation.
And Rajabala's judgment is still valid so far as the issue of educational qualification is concerned. Yes, the thing is very clear. It is coming out that right to vote and right to consent are two different. So when they are removing the chairman, they are accessing the right of voting, not their day-to-day activities.
Mr. Dr. Puja.
Obliged.
For hearing, item 11.
May I please, Lordship? Lordship, the leading counsel, Mr. ARBI is on lag at court number 17, Lordship.
I've already seen that when you both were smiling at each other. I've seen from your body language that nobody is going to, nobody is ready to argue them.
Lordship, he
You
is,
smiled and he replied, it's okay. After Puja vacation, yes.
Item 12.
highly obliged, Lordship.
You are the- You are the only counsel.
Yes.
My lord, no. Central government is the only council, my lord. Only thing is that they filed an affidavit as of now, in which they have brought out, this is a case, my lord, relating to compulsory retirement under Rule 48 of the CCS. Assam Rifles, my lord, being a paramilitary force, the Zawans are, my lord, some conditions are governed by the CCS rules. And under Rule 48, my lord, at 30 years of service, the service review is carried out. So some persons who are medically unfit, my lord, they are, my lord, discharged from service. And some persons, my lord, who are otherwise thought not desirable to be retained, are also, my lord, discharged from service.
So
Our case, my lord, comes under second category. The first category, medical fitness is there. The second category, my lord, is basically where
undesirable.
undesirable. This undesirability, my lord, is basically, as far as Rule 48 is concerned, it is supposed to be a review of his entire career and find out ingredients as to whether he is good and good enough to be retained in further service. Now, my lord, the issue was already decided by the Meghalaya High Court in a division bench that we had relied upon. The Meghalaya High Court said that no, this is an issue which requires that if something undesirable is, my lord, taken into consideration from the ACR, then necessarily those ACRs have to be communicated. So you cannot rely on any uncommunicated adverse entry in the ACR to retire a person or discharge a person under Rule 48 is the finding of the Meghalaya High Court. Accordingly, the division bench order has been also implemented and subsequent writ petitions also have been allowed. At that juncture, my lord, query was put, my lord, to the respondents as to what would be their reply to the same. In reply, my lord, they come up with a judgment now of the Manipur High Court, where in a division bench, my lord, a contrary view has been taken. So the Meghalaya High Court has taken one view in division bench. The Manipur High Court has taken another view in the
It's not Manipur.
We have to follow out of.
Tikendra Singh. Sorry, Tikendra Singh. Oh, sorry, Tikendra Singh is also Meghalaya High Court, but then it's a order prior to this second order, my lord. There was an earlier judgment in which, my lord, the contrary view was taken. So as to which of these two judgments would prevail and
Prevail, to be followed.
to be followed, my lord. They are both prevailing, in fact. In fact, in the second judgment, my lord, because the earlier judgment, my lord, would know that Vaikunthanath's case was followed. That the compulsory retirement is not a punishment, and therefore, communication of the ACR and non-communication of the ACR is not a issue that is to be gone into, my lord. But this Vaikuntha's judgment, my lord, has been considered by the division bench later again, when this communication of ACR was held to be mandatory. And that part, probably, my lord, the second judgment has probably already looked into. And therefore, the compliances have come thereafter. That would be the main crux of the case, my lord. Because Vaikuntanath and the other cases, my lord, there are around 7 judgments that have been relied upon by the single bench also. All these judgments, my lord, are relating to compulsory retirement where a person was specifically found to be, my lord, having doubtful integrity, or there were some, my lord, ill behavior towards superiors. They were found to be of shady characters. They were found to be of doubtful integrity. And what I find, my lord,
Yes.
what I find is that the learned single judge here, my lord, had relied upon, though not specifically quoted, the language that is used in this earlier case of Tikendra Singh, where compulsory retirement was said to be not a punishment, and therefore that was also by Meghalaya High Court, my lord. The 7 cases that were relied upon in the earlier writ appeal were cited by the learned single judge only. And I've made a, my lord, comparative study that these are all cases of, my lord, where overall assessment of the career was made and a person was found to be of doubtful integrity, and therefore communication as such was not necessary.
Upadev Singh case,
My lord.
which the learned single judge has disagreed or whatever they not decided to follow,
My lord.
is in relation to this compulsory retirement.
No, it is in relation to communication of adverse interest in the ACR.
In relation to FIA, this promotion.
Promotion, my lord. In relation to promotion. My leg of argument would be, my lord, if it is necessary for promotion, my lord, if I am to be discharged from service, it carries a greater burden, my lord. Promotion, yes, if I am denied promotion, I am still in service. But then here, acting on an uncommunicated entry, you are altogether discharging me from service, my lord.
Compulsory retirement did not be treated as a punishment.
I understand, my lord. I understand, my lord. But the distinction now sought to be made, my lord, here, as by relying upon this Tikender's judgment, my lord. That aspect about Vaikuntanath, my lord, has been already discussed. The Meghalaya High Court Division Bench order is at Annexure 4, my lord. Page 117.
117, Union of India versus Joseph.
Joseph case, my lord, which has been implemented, my lord. Now that aspect of Vaikuntanath, my lord, and compulsory retirement was considered, my lord, in para 22, page 122. Such proposition that the older judgments reported in so and so are placed into service by the appellants. And what was probably not also considered in the earlier judgment, which is sought to be relied upon, is that
Tikendranath has not taken into consideration it.
my lord,
Vaikuntanath is considered not, but in Tikendra ji also.
Vaikuntanath, but Tikendranath, the judgment of the Meghalaya High Court was not taken into consideration in
yeah,
this.
my lord.
Is-
Specifically, my lord, not referred to here,
Not even referred.
not even referred, my lord. But then the same considerations seem to have been argued, my lord, in the Joseph's case, my lord.
But if the
And then in
case-
addition to that, my lord, what was not considered earlier in Tikendra's case is that there is a ROI of the record of instructions of the Assam Rifles which is followed, page 126, para 37, my lord, that particular ROI makes it obligatory for communication of the communication of ACR is obligatory, my lord. And in our case, my lord, how we distinguish ourselves from Vaikuntha's case and the other cases is that in the other cases, my lord, the overall assessment of the career was made. In our cases, my lord, there is no disciplinary violation at all. Just that, my lord, for particular year, I did not attain the benchmark in my ACR. Otherwise, there is nothing adverse against me,
That can't be a good ground.
my lord.
Ultimately, it's a discipline force.
My lord. No, I have not violated any discipline, my lord. Had that been a case, because Vaikuntha and the other cases, my lord, are cases where there were disciplinary misconducts, my lord. There were DPs drawn, there were misbehavior towards superiors. In my cases and in these cases, my lord, no such consideration was there. So the overall assessment of my service careers, which is required, my lord, was not done. Just based on that, in my last 3 previous ACRs, my grading was not above average. This discharge order has been passed, my lord. And everybody, my lord, why it pinches, my lord, everybody who had gone to Meghalaya High Court based on Joseph's case now has been, my lord, either given a chance to represent again, and some of them have been taken back also, my lord, in service, my lord. Whereas because of our single judge's order, my lord, people who were before this High Court, my lord, are stuck.
That is the prerogative of the High Court.
I understand, my lord.
You can't.
But then in my humble understanding, my lord, the division bench in Joseph's case, my lord, had taken into consideration Vaikuntha's case also. And
So
based on that, but
suppose if the clear judgment of the same High Court has not been taken into consideration,
then, my lord, then of course, my lord, this DB has to lay down the law, my lord.
this DB, ultimately we have to observe that this judgment is per incuriam. This Joseph judgment. Clear judgment.
Yes, of course. If it was not discussed, my lord. But then after holding it to be per incuriam, my lord, probably this honorable court will lay down the law also as to whether communication of ACR is necessary or not, my lord. Because there are distinction of facts between those cases and these cases, my lord.
The Tikendranath judgment.
My lord, it is annexed.
My affidavit in the additional, affidavit opposite in the additional affidavit.
Tikendra Singh, my lord, the additional affidavit has been filed by.
Task from page 1. The relevant, the discussion of other case laws, the last paragraph is the observation. Paragraph 12, page 193 is the observation. After discussing all those case laws.
Sikandar Singh, my lord, has given the reasoning which is actually followed by the learned single judge of this court.
From the road, the same will be controlled about the.
Yeah, right, to the PSC. My lord,
You can come to the.
my lord.
Paragraph 22, because in Abhijit Singh Bhattida, while para 84 said that the armed forces, it will not apply to the armed forces,
My lord,
this communication.
my lord,
That was reiterated in Sukhdev.
my lord.
Then para 22, why was this view taken? Therefore, in light of the majority, so before you, we consider appealing the method decision have more precedential value than the case of so where previous decision of so was not taken.
Look, this observation is made in light of the comparison between the husbands were made and presidential value of Vaikuntanath and others was, my lord, held to be higher because they were of a, my lord. And they were, my lord, held to be of a higher presidential value because they are, my lord, upheld by a larger bands.
Directly on the point also.
Directly on the point, directly on the point.
But what do you say about this? That Abhijit Singh Bhattida,
My lord.
this will not apply to.
Armed forces.
My lord, particularly in Assam Rifles, since we are governed by the CCS rules, my lord, in armed forces, my lord, the rules are different. In armed forces, the rules are different, my lord. In army, the rules are different because we are governed by CCS. And there is a,
By 6 years to the extent, like CRPF pension, CRPF was also governed.
yes, but then for us, my lord,
But the discipline and all, the army rule also applies.
no, there is a specific ROI for us, my lord, in this regard, which has also been cited that communication is necessary. There is a procedure of communication and that procedure of communication has to be followed. And in Joseph's case, my lord, that para, therefore, at para 27, my lord, at page 123.
Yes. Paragraph 3 of the advisory.
My lord. And again, in para 37, my lord, this ROI is specifically quoted. Para 37, 126, this was taken into consideration, which was probably not discussed in the earlier round of litigation. That so and so has to be read in the scenario of act of not recommending an employee for promotion in the context of such employee being retained in service after completing the specified number of years or attaining a particular years, rules out such employee from being considered for retention in service.
That this office instruction is in relation to promotion.
No, my lord, as a whole for communication of ACR. For communication of ACR. এটা তো জানি।
Yes, madam.
But I would have liked to, my lord, place the fact that the 7 judgments of the apex court that is relied in Tikendar's case and also by the learned single judge, my lord. If we read those judgments in details, my lord, there are paragraphs in all these cases that reveal that the overall assessment was made not just based on ACR. The overall assessment was made to find that the person is not desirable because he lacked in integrity. All these cases have this finding. In my case, my lord, it's simply the order which says that you are not required because you are not meeting the ACR criteria. So a distinction has to be drawn, my lord.
Those rules which were there.
My lord.
Required that the whole service has to be looked at
My lord,
along with the service dossier.
my lord. My lord, that is also the purpose of Rule 48, my lord. Rule 48 does not say you review it on the basis of ACRs only.
Gap is there, so they.
This is a procedure that is now evolved by them thereafter.
That is a gap in the rules, so they have. They have added to that, supplemented to that by the RO inspector.
My lord, I understand that, but then that has to be also read in the context that, my lord,
But ultimately, all those cases,
my lord,
the issue was this non-communication of ACIs.
my lord,
And on that point, the consistent view is that These, for the purpose of compulsory retirement, these,
It's not a
ACRs are not to be, are
Yes,
not
yes,
supposed to be
yes,
communicated.
yes,
This is what the
yes,
crux.
yes,
What,
yes. But then in those cases, my lord, again, the fact remains is that those persons who were compulsorily retired were of doubtful integrity and they lacked, my lord, discipline. There's no such finding in my case.
let us see. What is that?
My lord, I had also placed that though the Tikendra's judgment was there, after Joseph's judgment, my lord, everybody who were, my lord, before that court and in subsequent round of litigations also, my lord, people have been allowed by the Assam Rifles thereafter to represent against that adverse ACR.
Withdraw this petition and go for the Meghalaya High Court.
That reply I have given lordship, that why those person who same benefit the petition or appellant is asking. So why they were given and why he cannot rely upon that is in my affidavit lordship.
Your-
Yes.
My lord, they basically said that, of course, they are in different jurisdictions, of course. I understand that. But then we are after all in the same service. And if this is to be read, my lord, this communication if of ACR is to be read as not a mandatory criteria, my lord. It basically opens up the door for them to throw us out, my lord, at the exit
He
of the
already
employer.
retired in the year. There is no stay, so he had already
He is
retired.
He is
lordship.
retired.
Yes.
In the age of superannuation,
Yes,
My lord,
he
he has
had
attained-
already in 2022, he retired.
My lord.
2022.
Yes.
And in fact, in
And
view-
immediately.
but then in view of the pendency of this petition, my lord, his pensionary benefits have been also not lost.
Your compulsory retirement which year?
My lord,
He was asked to appear 1st January 2018, then a stay order is there. And after single bench, single judge's order, although he had filed a stay petition, but it was not considered, so immediately he retired.
The
On the
retiring
age of-
pension order is at page 135.
After the judgment itself.
After the judge,
Judgment.
After the judge.
not attaining
Not-
the age of superannuation.
On attaining superannuation, my lord.
Stay order was there and subsequently he attained superannuation.
No, but till the date of judgment, he was in service.
He was in service,
Yes.
my lord.
And so he attained the age of superannuation in which date?
Immediately during
would
the
like
time
to-
of filing of the appeal.
I did, yes, sir.
Yes.
What's the retirement age in the Assam Rifles?
60.
60.
60.
And this appellant, this attains the age of superannuation
No,
on
no,
which
my lord.
date?
In fact, he was thereafter discharged, my lord.
Huh?
Was
Discharged to her, but ultimately whether you have now completed 60 years or not. Today,
No, he had not completed 60 years.
today is not 60
Not
years.
60 years.
Appeal. If it is sworn in 2017, he was 47. So-
Then still is.
My lord, 5 years of service is still there, my lord. Otherwise. But then on, after the judgment, my lord, on 13 August 2022,
After the judgment, he has been discharged. and
Discharged, he has been
no
discharged.
stay there.
there is no stay. On 13 August 2022, he was discharged.
What is this?
My lord, I would only rely, my lord, that last few paragraphs of the Joseph's case, my lord. In my humble understanding, my lord, the difference between Vaikuntha and these cases, it was looked into.
18 to 22 in service
My lord,
with salary.
with salaries, my lord.
Okay.
Deeply oppressed.
Item 13 and 14.
What is it?
Lordship, in these two matters, I am appearing for the appellant in item number 14, Lordship.
Yes.
Lordship, this is a case, Lordship, where the president of a particular Jilla Parishad resigned just before the date of voting on the no confidence motion. Thereafter, he withdrawn his resignation. There is a provision in the Panchayat Act that government 72 and 73. Lordship. Lordship, although the resignation was withdrawn, government declined to accept the withdrawal of resignation on the ground that it is not in terms of section 72 of the Panchayat Act.
Then he preferred this, writ and writ petition came to be allowed.
Yes, a petition came to be allowed, and after government's decision, I was appointed as the in-source president of the Zilla Parishad. Lordship, writ petition was
You were appointed as
the in-source president of the Zilla Parishad.
vice president.
I mean, item number 14. Now, against that order, Lordship, the instant appeals has been prepared, and we are enjoying the stay order, Lordship. Lordship, in the meantime, in the month of February 2024, the term of the Zilla Parishad has
It's
expired.
already over.
Yes.
What
So-
remains then? Nothing.
So case-wise, Lordship, nothing is there, it's only academic.
Only for academic.
But in the other case, Lordship, government is represented by the learned advocate general, Lordship, in the other case, Lordship.
The other cases,
Item number 13. That is an appeal by the state.
that is state of Assam versus Ashish Nath.
Yes, Lordship. The only concern,
Acha, you are in this Bimola.
I'm in Bimala Shukla Bhatta, Lordship. I'm the in-charge president. Lordship, only concern of the state, Lordship, as the case has been settled in the writ petition, Lordship, that may remain as a precedent without being deciding this appeal, Lordship. That is the only concern of the state.
Who is appearing in that on behalf of state?
Learned advocate general is appealing, Lordship.
That is you.
So, Lordship, only that protection is allowed, Lordship. In an appropriate situation, Lordship will decide the issue. But so far as that case is concerned, Lordship, that judgment will remain only to the extent of the facts of that particular case, Lordship. That much protection is sufficient for us.
Decide in this case itself. What's the problem? We'll decide in this case itself.
Lordship.
It is open for us or we can't decide.
Lordship. For me, Lordship, no issue is there, but
No.
for the state it's an issue.
Then
Lordship.
you do one thing, you withdraw your writ appeal.
Then Lordship, right now, Lordship, Learned Advocate General is appearing in another matter, Lordship, in another court.
No, you
Then
withdraw
Lordship
your,
may fix a
your
date.
writ appeal. Appeal. We'll
Both
decide
cases
your-
are together, Lordship. Lordship will decide the issue, Lordship. The Lordship will
decide the
fix a
issue, but
date.
you withdraw this and will hear the state that matter in that appeal.
Lordship, it would have been,
We'll observe that you are withdrawing it without being affected by and your withdrawal would not affect this merits of the writ appeal filed by the state.
Lordship, that may be that. But Lordship will make that an observation.
These two writ appeals. 13 and 15. These two writ appeals have been preferred by the appellants. These two writ appeals have been preferred by the. In these two writ appeals, the order dated 18/8/2022 passed by the learned single judge in writ petitions number 5512/2021 and 5615/2021 is under challenge. Full stop. The issue involved in these writ appeals is to the effect that whether the state government can refuse to accept the resignation of what is the post he is holding?
President,
President of a Gram Panchayat.
Zilla Parishad, Karimganj Zilla Parishad.
Zilla Parishad.
Yes, Lord.
President of
Karimganj.
a Zilla Parishad. Even though if the same is filed, if the same is submitted according to the procedure while taking into consideration the other mitigating circumstances. Stop. Learned Counsel, Mr. Nayak, appearing in writ appeal number
291.
Writ appeal number
291-2022.
291/2022, as submitted that since the term of the Jilla Parishad has already expired and the appellant is no more holding the temporary charge of the president of the Gram Panchayat of the Jilla Parishad. The writ appeal filed on behalf of her has become infectious. Full stop. Taking into consideration the above facts and circumstances of the case, the writ appeal number 291/2022 is dismissed as infectious. However, the dismissal of the writ appeal number 291/2022 shall 291/2022 shall not prejudice the merits of the writ appeal number 289/2022 preferred on behalf of the state of Assam. This writ appeal number 289/2022 after puja vacation for hearing. Acceptance of resignation, acceptance of withdrawal of resignation. Acceptance of withdrawal of.
Item 15.
Yes.
Also, in this case, lots of mileage justice Nair may not like. Yes.
In this case.
In earlier case, in single bench, lots of illegal equipment.
Yes, my lord, may I just pay for a fixed date in the next one after vacation?
Here, making an exception, how can we fix a date? We take the date from the registry, another bench, justice only.
Item 16.
Please, my lord, this petition is against an order of the Central Administrative Tribunal. Now, my lord, what happened? The petitioner, I mean, the respondent was
Yes.
my lord, the respondent was working as depot material superintendent in Jogigopa. Charge sheet was issued on 8/7/2008. And an inquiry was held and it was imposed a penalty. That penalty was challenged before an appeal was filed, appellate authority modified and during the pendency of that proceeding, there was an order from the railway administration that his salary will be withheld for the purpose of recovery of the loss. Now, the petitioner challenged that order of penalty before the Central Administrative Tribunal, and the Central Administrative Tribunal remanded the matter for fixing responsibility. I'm drawing your lordships to the order of the Central Administrative Tribunal, my lord, that was passed on 12/2/2016. This is page 41. I'll draw your lordship's attention to the operative part. We are of the view that from the entire facts and circumstances of the case, and by taking into consideration the year, that is 20 years, where the applicant was not only responsible, there are else than the applicant and more important part of the respondent authority for investigation was lacking. Thus, it is established that there is a lapse on the part of the respondent railway authority. Hence, it will not be appropriate justice to put the applicant by fixing him as a full responsible by recovering the entire amount from the applicant. Accordingly, we set aside the impugned orders dated so and so and so and so and send back the matter to railway authorities to investigate the matter properly, as we feel that there is a need for thorough investigation before fixing responsibility only on the applicant, that too before coming to a conclusion of the departmental inquiry initiated against the applicant. Now, my lord, the charges were that there was shortage of structural materials and shortage of P-way materials. That is, my lord, the railway lines and all. So for the structural materials were concerned, the inquiry officer held that it was not or partially accepted. Partially, yeah. But so far the P-way materials are concerned, it was established that he was the person who was responsible for the shortage. Now, my lord, Central Administrative Tribunal remanded the matter. In terms of that order, we constituted a board of inquiry. Lordship may come to page 60.
Yes.
The board of inquiry again took up the matter and gave a finding that the P-way materials, shortage of P-way materials is established against him. Now, my lord, the original penalty was issued in the year 2009, and my lord, during the pendency of the earlier writ petition, my lord, OA, the respondent had already retired from service. Now, my lord, as your lordship is aware that if there is a loss and the loss is to be recovered from an employee who has gone on retirement, it has to be done under the pension rules. Now, after the order of the
This inquiry, the department of inquiry.
not the department, that is the board of inquiry constituted after the matter was remanded, its finding was challenged. Now, this time the Central Administrative Tribunal, I'm taking your lordship to the operative part, says that no, you cannot recover anything from him now.
For
That-
what?
Yes, because now what we have done, the initial order whereby the matter was remanded was never put to challenge by the applicant.
Wait.
The earlier order
Yeah, whereby the.
matter was remanded.
tribunal is
Remanded. So whatever we have done, that is the constitution of the board of inquiry and finding the thing was done as per the direction of the tribunal. Now the tribunal is saying, my lord may come to the operative part. The lordship will come to page 112, page paragraph 16.
Yes.
In the instant case, as we have already discussed in the foregoing paragraph, that the applicant has already been inflicted a major penalty of reduction to a lower grade, that is from the present so-and-so to so-and-so with restoration to original grade and pay after 5 years period, which is duly served by the applicant. And that upon this tribunal in his earlier litigation has set aside the recovery orders dated so-and-so on the ground of fixing the applicant as a fully responsible for recovery of estimated amount of so-and-so, as much as there is no such charge of misappropriation or misconduct, else charge of lack of integrity and lack of devotion to duties. Thus, in these circumstances, withholding of pensionary benefits in lieu of entire estimated amount for recovery is not at all permissible under the law. And then my lord directed to release his pensionary benefits. Now, my lord, the question is the imposition of penalty was already there when the first round of litigation was taking place. The tribunal, having taken note of the fact that he has been imposed with a penalty and he has served the penalty, remanded the matter. And that
In the first time.
in the first time. So it is not that the penalty issue of imposition of penalty came to the notice of the tribunal subsequently. That incident was already there. Having aware of this, the tribunal has remanded the matter for fixing the responsibility. Earlier, my lord, the entire responsibility was fixed upon him. The lordship will have a look at the charge sheet. It says that I'm taking your lordship to the
Board of inquiry has fixed the responsibility of whom?
the petitioner, I
Okay.
mean the respondent, to the aspect of shortage of POA materials. I'm taking your lordship to that one.
Here, the entire penalty was upon him.
My lord.
The entire.
Initially, the entire recovery was upon him, but now we are confined to the recovery. We are confined to recovery to the extent of the shortage of POA material. Lordship will take, have a look at the findings of the Board of Inquiry, my lord. My lord, page 73.
Page
73.
76.
73, my lord. All the documentary evidence, inquiry report and statements given by so-and-so and remarks made by the committee members in the above paras concluded that the charges framed against article so-and-so, so-and-so, and so-and-so are as follows. Number one, article 1, for shortage of materials under his custody, structural steel materials partially proved and POA materials proved. So now the responsibility of the POA material was fixed on the employee or the respondent because he was the only person who has received that thing. Now the value of the POA material comes to around 87 lakhs something, which your lordship will find in the charge sheet. For a moment, may I draw your lordship's attention to the article of charge, which your lordship will find at page 17.
And in this judgment, the learned single judge has not interfered with the findings of the Board of Inquiry.
No, my lord.
They have
Not single judge, my lord, Central Administrative Tribunal.
Sorry, Central Administrative Tribunal has
No,
not
no. There is no interference. That thing, there is nothing about that the findings of the Board of Inquiry is bad. If we go through the operative part of the judge, order, we'll find, my lord will see that the whole reason for
that he has
interference,
already.
that earlier he has already served the sentence or the punishment, so it cannot be done now.
Now, from the earlier this order, you just show us that this fact was taken note of this, that he has already served the sentence.
Yes, my lord. In fact, my lord, this this issue was there in the argument. Lordship may come to page 44. Paragraph 5. Learned counsel further submitted, that is the counsel for the applicant, further submitted the impugn notices so-and-so were issued to the applicant intimating balance 81 number of stock deficiency in the custody of the applicant and the recovery of amount to the tune of so-and-so, which would be recovered from the salary of the applicant. Learned counsel further submitted, once the proceedings started with the article of charge, and that too after verification only 3 times during the tenure of the applicant of 20 years, the punishments were imposed and the applicant has already served. Subsequent recovery amounts to double jeopardy, which is not sustainable in law. Now, my lord, the plea of double jeopardy, that is serving sentence and recovery, was taken advanced by, but it was not answered. My lord, if that was not answered and the matter was remanded, so in my respectful submission, that was rejected. And against that order of the tribunal, no writ petition was filed. And in absence of any challenge to that, it has attained finality, my lord.
My lord, may I have a look at that article of that? लिखा है सर, I don't remember.
Yes, Mr.
My humble submission is there. One charge sheet was issued in the year 2008. Inquiry was conducted and penalty order was imposed. I appeal and against the appeal, I submitted my departmental appeal against the
You
penalty,
submitted?
my departmental appeal against the penalty order.
Again, appeal mein the penalty was revised.
Very well. Then, my lord, my humble submission is that charge sheet in initiation of the disciplinary concluded after imposition of the appellate authority's order.
You should have challenged that order of the cat.
Why
you have not challenged that?
No, my lord, I am coming one by one.
Huh.
Now, my lord, my isolated order has been passed for recovery. Although I am coming one by one, my lord, I am coming one by one. Then, my lord, isolated order was passed for recovery. For recovery, my lord, railway services discipline appeal, it is a penalty, minor penalty comes under the minor penalty. Discipline and appeal rule of the railway. And I have been imposed a major penalty, but I have not challenged that major penalty. Subsequently, they have passed recovery order. Recovery should subject to an inquiry. This charge sheet and an inquiry. Because it is a minor penalty under the appeal rule. Both of the order has been set aside by the tribunal. My first round of litigation when I approached this tribunal.
Both of the orders, which orders? Both of the orders.
Both the orders, my lord, I am coming to page 38.
You show us those orders.
Yes,
Which
38
were,
and
which was under challenge before the tribunal.
Tribunal.
In the earlier litigation. What was those orders?
Those order, my lord, I am coming to page 39 and 40.
Yes, recovery against finalization.
Yeah. These order notice given for recovery against finalization return stock share. The balance return stock sheet submitted by you with remarks of closure, but the after scrutiny it has found that remarks given by you are not convincing, acceptable, the same return stock sheets and headquarter necessary closure and recovery. As per headquarter approval of cost of shortage of the materials after considering 2% tolerance shall be recovered from your salary paid procedure towards finalization. Then mail at page 40, order of recovery. In terms of the return stocks, then 2 crores 37,180 only is approved from your salary bills. Those order I have challenged in the first line and then set aside. Now at in finality, these are non-existent.
Fine.
Then, my lord, I approached the tribunal again because the tribunal remanded the matter for inquiry. I'm coming.
What was the direction of the tribunal?
Tribunal direction is that I approached the tribunal for release of my gratuity and pensionary benefit.
You just read.
I am coming, mail. One by one.
Sir, you have not only approached the tribunal with the release of this gratuity and pension.
Yes.
You have also challenged that order.
No, my lord, kindly come to page 74. No. Page 74, my second round of litigation.
We are not on the subsequent proceedings.
Subsequent.
In this first OA number 23 of 2004.
Yes, that investigation order I have not challenged. I am not submitting there.
So what you have challenged in that? In OA number 23 of 2015, what was under challenge?
That was under the challenge, those penalty order, that recovery order.
That recovery order?
Oh, yes, please.
Okay, not the penalty order?
Not penalty order.
The recovery order?
Only recovery order.
He was shocked and surprised when the respondent issued another order of sanction of recovery of amount of itna for the monthly salary of the alleged loss accounted by not maintaining so and so. This is what their precise challenge before that.
Smile.
And what the tribunal has said?
Tribunal has finding that, please, I'm coming to that. Page 58. We are of the view that from the entire facts and circumstances of the case and by taking into consideration the year of 20 years where the applicant is not only responsible, there are else than the applicant, an important part of the respondent authority for investigation was lacking. Thus, it is established that there is a lapse on the part of the respondent, that is railway authority. Hence, it will not be appropriate justice to put the applicant full responsibility by recovering the entire amount from the applicant. Accordingly, set aside the impinned orders dated 23/7/2010 and send back the matter to the railway authority to investigate the matter properly. As we feel that there is a need for thorough investigation before the fixing responsibility on the applicant, that before coming to a conclusion of the departmental inquiry initiated against the applicant. Then, my lord.
But we feel that there is a need thorough investigation before fixing responsibility only on that too. Coming to the conclusion, department initially against the appellant. that before coming to, that too before coming to the conclusion, so and so, so and so. So,
They did an inquiry.
uh,
They did an inquiry, fix the responsibility. I am coming on it. Then, my lord, for withheld of my gratuity and pension, there is a rule 9 of the railway pension rule. For rule 9 says, to withhold the pension and gratuity, there must be an inquiry when I was in service. If not so, then the incident should have been occurred prior to 4 years of my retirement. That is I have enclosed in my affidavit.
this, why you have invited all this?
No, my lord, I approached the second time for my release of my gratuity and pension, etc.
No,
Yes, second time.
no.
I am,
Come,
page,
come,
page 75,
come,
my prayer.
come.
Page 75, my prayer. That was my simple prayer. The Honorable will be pleased to direct the respondent to release all the retirement dues in full, including regular pension, leave encashment, gratuity, etc., for to the 20% interest thereon, with immediate effect without any further delay. The Honorable will be pleased to declare that the respondents are not legally entitled to make any recovery on the proposed loss and so and so by this, which are already set aside by inquest by the tribunal later so and so passed in November 23 of 2015. Then prayer 3, Honorable will be pleased to direct the respondent to refund the amount already recovered from salary applicant to the alleged ground of shelter. So, my lord,
Mr. Consul, after after submission of this report from the Board of Inquiry,
my lord.
is there any formal order issued for recovery of this?
No, that was not done because in the meantime, the petitioner has gone on retirement. I retired on 2015, now 10 years. Yes, the petitioner, the respondent employee retired on, my lord, 31/12/2015. The first round of litigation, the order was passed by CAT on 12/2/16, remanding the matter to the railway authority for investigation. That is, after his retirement. Now, the initial recovery proceeding was commenced when the inquiry was going on. But because of this, it was subsequently quashed and the liberty was given to make an inquiry. That order was not challenged. We made an inquiry and in the meantime, he has gone on retirement. So now after he has gone on retirement to make a recovery, we have to get a sanction from the president. Yes, rules I have included in my affidavit. Railway pension rules. Page 20 of my affidavit. 20 of my affidavit. Page 21 is the rule 9.
The CCS rule. CCS.
No, it is not the special rules, it is the railway service.
Railway pension rule. Railway pension. So
It is perimeter. It is perimeter.
Perimeter to rule 9.
Rule 9 of the, then rule 9. Now it is rule 8. In fact, the tribunal has held that that cannot be recovered, that is not permissible under the law.
Mr. Was there a stay order in the proceedings before this implementation? No proceeding.
No proceeding.
My lord, lordship will see.
There, my lord, 2015, 31st August.
No,
Yes,
2018, 19, when you.
yes, yes.
You have a stay order.
No, nothing, nothing. After inquiry, there.
My lord, lordship will see that the operative part is, it says that under these circumstances, withholding of pensionary benefits in lieu of entire estimated amount for recovery is not at all permissible under the law.
It's not permissible.
Yes, not permissible.
Because you have not done any proceeding to get that inquiry report finalized in the form which you can get a consent from the president.
Exactly.
As in from the president, the rule. You have not done that.
But
My lord, the law is that
My
there
lord-
must be a findings of a grave misconduct.
my lord will see that
First proceeding, you have come and a penalty was. Why was the order? Because you had findings before you in the inquiry report with regard to the loss of. There was a charge with regard to 2 crores loss. Right? That was held to be proved by the inquiry. So when you pass the penalty, why was the consequential order of recovery not?
my lord, that order of process for recovering was done prior to the during pendency. I'll draw your lordship's attention to
Dependency of what?
the first round of inquiry. I'll draw your lordship's attention to, lordship may come to page 77 of the writ petition.
Yes.
My lord, paragraph, it is stated by the applicant that during the continuance of the departmental proceeding against him, the respondent authorities informed the applicant by letter dated so and so that they had decided to withhold 50% of his salary to safeguard the railway's estimated loss towards shortage of materials of the stores. So, my lord, they had decided to withhold his salary to that extent. That means they were then, my lord, because if you
But this is not after you have quantified the loss recoverable from.
no, because that was set aside.
Quantified loss took place in the inquiry report.
No.
When the inquiry was going on, how you come to the conclusion that without there being any final conclusion in the inquiry that yes, you are entitled, you are liable for this, whatever the loss, and therefore 50% of the salary is to be, how, under what procedure you are doing?
Because my lord, lordship
With
will
the authority
see,
of the law.
lordship will see that there was a huge loss.
Huge loss. But despite that, how you if you come to the conclusion,
My
that
respect,
this person with the conclusion of the inquiry that this person is responsible, so withhold 50% of salary of it.
my lord,
It's very
my respectful submission in this regard is, my lord, everything was there on the record. The issue of.
Then why you have this troubled yourself with this inquiry? Either dispensing with the inquiry, you state when you have all the facts with you. You should have charged him,
My lord,
punished him.
my lord,
That is
here is
also
the-
one of the more.
my lord, here is the case that the issue of penalty and recovery was not there simultaneously with the order, and the tribunal was aware of this, and in spite of that, tribunal has remanded the matter for a fresh investigation to fix responsibility.
Mr. Chakraborty,
My lord.
the penalty, the charge against him is 2.04 crores plus. That was established in the inquiry. That was established in the inquiry, both PA and the structural. But when you pass the penalty, you can pass the penalty, that's the final order.
Yes,
You pass the penalty of reduction in time scale of pay.
my lord.
Now, why we will not be considered that that was the only penalty you did? Because the recovery order should have come along with that.
That is why I am submitting, my lord. My lord, that is why I am submitting. This situation was already there when the Central Administrative Tribunal had looked into the matter and remanded it. Because, my lord, after the remand, my lord, then the question of remanding will not have any impact, my lord. If we could not impose, or if when
Mr. Chakraborty, when you conducted this second inquiry,
my lord.
you have the order, you can come to the inquiry report, second inquiry,
The Board of Inquiry,
board of inquiry. Page 61.
yes.
You have gone back and relied on the initial charge sheet.
No
That
new
is
draft,
not,
no charges have been created.
No, my lord, what was the understanding when the tribunal, lordship will just give me 2 minutes time to explain. The tribunal,
We are from last half an hour, we are listening you.
my lord,
Where is the question of 2 minutes?
my lord, the matter went back to the railway authority. Tribunal was aware that penalty was imposed. There was no order of recovery along with the order of punishment. So in spite of that position, tribunal remanded the matter for an investigation to fix responsibility. Now we carried out that investigation, or in service matter investigation or inquiry. We carried out by constituting a board of 3 persons. Then what was the allegation and who is responsible for that?
that was not required. It was already established in the first inquiry. Right? Now, how can you refer back to that same very issue, personal notice? Issued memorandum of charge issued to him, which was concluded with the penalty. After that proceeding, everything has gone.
My lord, then what remained for investigation?
Mr. Chakraborty, now you are admitting that at the time of passing of this punishment order, the railway was supposed to pass an order for recovery of whatever the loss amount is there. That you have not done.
Not done.
Then whatever it may be, the person has approached the tribunal, and tribunal said, okay, first you quantify the loss and the person who is responsible for that, and then proceed further.
my lord.
Whether
And that order was not challenged.
that liberty given by the tribunal, the tantamount that though at the time of passing of the punishment, you have not ordered for any recovery, but now it is open for you to recover that amount.
Then unless,
How
my
can
lord,
it be
in,
initiate those proceedings, sir?
my lord, if we are not in a
Even though if the
position to
tribunal has
recover
passed
the
an
amount,
order,
then what purpose would be served by making an investigation and fixing responsibility, my lord? If after remand, an investigation or inquiry, if we are not in a position to recover, then what is the whole exercise for that fixation of responsibility, my lord? In fact, we have complied with the direction of CAT. My lord, if after remand, you carry out the exercise to fix the responsibility as directed by CAT, then if we cannot recover the amount, what is the whole
that should
purpose of?
be- that whatever it may be, you may fix the responsibility, but so far as regarding recovery of the amount, that should be in conformity with the law.
This is my. Now, if
Should be in the conformity, even though the tribunal, suppose tribunal tomorrow say hang him, whether the tribunal has the authority to do so.
my lord,
Though
that
they
order,
have granted you liberty, can do assess the damages and fix the responsibility.
but that
But
order
that
was
doesn't mean
never,
that,
that
you
order
have
was
the
never
jurisdiction
put
do
to
so.
challenge, my lord. That order was never put to challenge.
Not required.
Never put to challenge.
That order,
You should have challenged it,
my lord.
and you should have, there's nothing to laugh, mister.
My lord, it
That
is
was an
only,
order and you
my
were
lord,
also sitting
honestly
right over the
speaking, my
matter.
lord, my respectable submission is this
Both of-
order has given a lease of life to the railways.
That can't be.
Otherwise, my lord, now, my lord,
The provisions of the law.
now, after this recover order, the investigation was carried out or the inquiry was carried out. And there we had fixed the responsibility, or the board has fixed the responsibility to the extent of P-way material. It is P-way materials proved and structural steel materials partially proved. So, my lord, since we have, or in the investigation, it is the P-way material that has been established, my lord. So we are entitled to recover to the extent of P-way materials.
Under what authority of law?
Now, if that is established, if we can establish, if the inquiry establishes that he was responsible in terms of the order of the CAT, then under the pension rules, we can recover. Because everything happened prior to his retirement, and the proceeding continued post his retirement.
Pension benefits were not released.
Only
He was getting provisional pension.
provisional.
And there was no order with regard to withholding.
No. That
No.
that is a followed
It is,
rule.
my lord, it is immediately after the findings, he has approached and
No.
The OA number is,
19.
2019.
no, OA number is.
And there was no stay.
2019. 19, and the Board of Inquiry submitted his report on 9/5/18.
You see the OA number.
426 of
Of
2019,
2019,
December 2019.
and it was 9/5/2018.
District Tribunal 426 would be around.
Your lordship is very
So-
well here.
So what were you doing for this?
426. And tribunal also did not.
And the tribunal also, my lord, did not interfere with the findings of the Board of Inquiry. My lord, the tribunal has held that it is not permissible at all, my lord. That is what we are submitting before a lordship. The direction of the tribunal or the reason for interference that it is not permissible. It is not that we have not done anything, that is why it should be directed.
But after remand by this tribunal, we have this board of inquiry has conducted a de novo inquiry or whatever it may be, after providing opportunity of hearing to it.
Yes, yes.
Where is
He
that?
participated now. Page 60. As per the Honorable Tribunal Guwahati directive, the three-member committee consisting of so and so has been proposed by so and so, by the order dated so and so. Srimati so and so has been nominated as convener of the Board of Inquiry to investigate the departmental inquiry against so and so.
Page 61 is the same chart.
Now at serial number 7, the inquiry fixed on so and so could not be materialized as Sri Gangadhar Datta, the employee, owing to adverse health conditions brought out by order letter dated so and so. Now, my lord, that no presenting officer was appointed by the disciplinary authority in case. The CO has also.
This, whatever the period in whatever the loss caused to so and so, this was period commencing from
1991, 92, 1993 to 2006 and 2008. That is from page 15.
last 2008.
Last 2008.
Chakravarti,
My lord.
this, whatever the loss was to so and so, or whatever it may, that was up to 2008.
My lord.
This person was retired in
2012,
2015.
2015.
2015. After his retirement, for the recovery purpose or whatever it may be from his pensionary benefits, which rules are applicable?
My lord, if a person, rule 9 of the
Rule 9.
pension rules,
What rule 9 says?
my lord, the president reserves to himself the right of withholding or withdrawing a pension or gratuity or both, either in full or in part, whether permanently or for a specified period, and of ordering recovery from a pension or gratuity of the whole or part of any pecuniary loss caused to the railway. If in any departmental or judicial proceedings, a pensioner is found guilty of grave misconduct or negligence during the period of his service, including service rendered upon his re-employment after retirement, provided that the Union Public Service shall be consulted before any final orders are passed. Provided further that where a part of pension is withheld or withdrawn, the amounts of such pension shall not be reduced below the amount of rupees so and so per mention. Now, my lord, here the proceeding started before the proceeding started before his retirement, and it continued. My lord, it started before his retirement, it continued, and after his retirement.
If not instituted.
No.
Provided.
While the railway servant was in service, whether before his retirement or during his reinstatement,
No,
shall not
is
be
found
instituted, say with the
Provided. Go below, provided.
My lord, 9B. Provided 9(1). Then 2 come to 2. So, my lord, under Rule 9, if it is instituted before his retirement, then it will continue as if he is an employee for the purpose. But if it is after retirement, then with the sanction. Now, here in this case, the departmental proceeding was initiated before his retirement. Now it continued. Central Administrative Tribunal remanded the matter for fixing the loss. Now, Lordship will have a look once again to paragraph 60, how the Central Administrative Tribunal decided in this particular case. In the instant case, as we have already discussed in the foregoing paragraphs, that the applicant has already been inflicted a major penalty of reduction to a lower grade from present so-and-so with restoration to original grade and pay after 5 years, which is duly served by the applicant, and that upon this tribunal in his earlier litigation set aside the recovery order dated so-and-so on the ground of fixing the applicant as fully responsible for recovery of the estimated amount so-and-so, as much there was no such charge of misappropriation or misconduct, else the charge of lack of integrity and devotion. Thus, in these circumstances, withholding of pension is not permissible under the law. Now, my lord, the tribunal in the earlier round, in spite of knowing the fact that the penalty was imposed, but there was no order of recovery along with the order of penalty, remanded the matter to fix the responsibility. Now here we have fixed, we have in fact complied with the direction of the tribunal. Now tribunal now takes a U-turn and then gives a decision contrary to what it was decided earlier. Even while doing so, my lord, the tribunal has not for a moment did not say that the findings of the Board of Inquiry is bad. Now the question is, if the findings of the Board of Inquiry is there, not interfered with, and it is done pursuant to the direction of the tribunal, then observation that it cannot be recovered under the law or it is impermissible under the law is an illegality in view of Rule 9, my lord. It is not the tribunal's finding that we have not issued notice or not. Tribunal has recorded a finding or gave an opinion that it is recovery is impermissible under the law, which is that, my lord, in my respectful submission, contrary to Rule 9 of the pension rules. It is permissible. And for that reason, that having come to a conclusion that it is impermissible, the tribunal has directed for payment.
The order is
Right.
We'll take the matters on the other day, remaining matters.
Okay.
Item number 70, can it be on first of October? First of? No, October.
What's the
Item 17.
कितना की urgency है?
Actually, not urgency.
Not 1st of October, because I'm having matters. I am having matters on the next week. And next week is motions day, as your lordship. Is it after vacation? After vacation. Can it be on 6th or 7th November?
No.
Or in the,
We'll fix the date.
yes, lordship.
We'll fix the date after vacation.
It's per convenience of the court.
Section নহয়, এইটো হেৰি পেলাই দিয়ক, pencil. হেৰি হৈ গ'ল। আপোনাৰ পূজা কিন্তু CAB হ'ল। এইকেইটা ৰাখি দিয়ে আৰু বোলে CAB ৰ পিছত লৈ আহে।
কেতিয়া দিব এইবিলাক মেটাৰ? এইকেইটা মেটাৰ কেতিয়া দিব? আহি যাব।
CAB এতিয়াতো